Morning. Welcome to our motor vehicle legal report. Today's date is July the 26th, 2022. We have our commissioners here today for this report. Nate Jackson, Chairman. Commissioner Stan Norton is present. Commissioner Jim Galvin is present. And our own Chairman, John Roberts, is present. Commissioner Carl Kramer is present. And Commissioner Ian Levy is present. We also have with us our Director, Lawrence. We have Jason Gillian. Barry Whitser is in the back. We have our Assistant General Counsel, Erica Smith, and our Assistant General Counsel, Taylor M. Hilton. We also have with us Bob Weaver, / retired. And I think we got his predecessor, Everett Singer. Signer. Oh, Signer. Okay. I'm giving you a new title then. Sorry about that. So with that said and done, I see another gentleman in the audience. I don't know his name.
That's Chris, our paralegal.
Chris, okay. Welcome, Chris. So with that said and done, who do we just have come in?
Only speaker.
Huh?
She is the,
Only speaker.
yes, she's the Nissan new
Well, welcome. What's your name?
Alani.
Aleni. Speaker. Oh, when you said speaker, I thought you was going to be the speaker today. No. Excuse me. Okay, with that said and done, I guess we're going to get started. I do know our chairman probably have some question about the legal report, and then we'll move on to the next commission that may have some question about the legal report. Okay?
I'll be honest with you, that's about as clean of a report I've ever seen.
Absolutely. That's off.
You ladies did a good job. And but just a few, just to go over. Number 6, could there be an effort be made to locate the dealer bond information in existence when this, when this complaint arose?
The complainant was sent their bond information by centralized the complainant was sent their bond information by centralized complaints. Is that what your
Okay.
question?
Yeah. Number 7, I would prefer a letter of warning as opposed to an assessment.
Okay.
Alvin, I totally agree.
Commissioner Norton, do you agree?
Agree.
Commissioner Levy?
Yes.
Commissioner Kramer?
Yes.
Okay, and I do agree.
Okay, I noted that change down on there.
And number 8, just a question, non-refundable down payment. Did the dealer get the customer to agree to that in writing?
Yes, they did. They provided the
They did, okay.
documentation of their signature on there.
Okay.
Question to that. Would that fall under our jurisdiction? Or would that be a
That'd be a civil matter, right? Be a civil matter. Didn't agree to it. We couldn't force them to give that back, so they'd have to go through the civil court process.
And number 49, did this incident occur before or after the changes in the ad rules? In either event, I might be inclined to issue a letter of warning as opposed to issuing a civil penalty.
And you were, what was, can you repeat the question?
49, did it happen before or after the ad changes?
It happened March 11th, so that would be before. Yes, before.
In either event, I mean, I would still be inclined to issue a letter of warning.
Okay.
Okay.
I concur, Commissioner Norton.
Jackson concur. Gavin? Yes. Commissioner Kramer?
Yes.
And Commissioner Levy? Okay.
Commissioner Galvin, number 5. I thought that was pretty interesting. Let me get my notes here. The gentleman apparently says he's selling vehicles off his front yard, but he says he's making it a car lot. Okay. My question is I think there should be a warning or a fine on this. Even though he said he only sold 2 vehicles in less than a year, that tells me that he's had more cars on that lot in his front yard for over a year trying to sell it, even though he didn't sell 2. I think there should be some kind of action or a fine or a warning on this gentleman right here.
We can issue a letter of warning instructing them.
I know he's doing it all year. It just happens he only sold 2. It might take. I'll open up for discussion.
I don't know if we can assume that he did something.
Well, when you say right here, it says in his yard set up for a car lot. Well, what does that tell you?
For the relevant fact.
I think maybe the best thing would maybe do a letter of instruction just informing him of the rules and regulations pertaining to what he has to follow.
Well, in fact, those 2 vehicles, cars, are they?
We looked at the titles. They were signed with his name, his personal name. Yeah.
Commissioner Jackson, I noticed they said they would apply for a license. Do we know whether they applied for a license?
I do not.
I think it's appropriate what Commissioner Gavin has said, letter of warning with instruction. I think that'll be appropriate. But I am concerned about, you know, they did say they're going to apply for a license. That lets you know that they intend to continue to do something that's maybe inappropriate. So.
Yeah, I think a letter of instruction just informing them would
Okay, great.
maybe be the
Great.
most appropriate.
Yes.
Gavin, you got any more?
Number 9. I just thought it was interesting that the new dealer took over this situation on the complaint, even though that the complaint had a lawyer involved. To me, if the lawyer got involved as a new dealer, I wouldn't want to get involved in this deal. So I wouldn't close the case. I would sort of open.
So we do not have a copy of the file. I reached out to the respondent, but they are, since they're closed, they basically were not really too worried about providing anything, and they said the new dealer has all the information. So that's why I wanted to open up a complaint against the new dealer to try to have an investigation conducted to get all that information. That's why I was closing and flagging against the respondent and then recommending opening a new complaint.
Involved in. Yeah, I wouldn't want to get involved.
From what I've heard from the complainant and the respondent, they do know, but I haven't spoken with the new dealer. That's why I was wanting to open the new complaint, to have an investigator go out and speak with them and get all that information.
Why don't we agree to do that?
Yeah.
Yeah,
But she has, where is that decision?
that's in the recommendation.
Yeah, to close and flag this complaint addition. Council recommend opening a complaint against the new operating dealer to get an update on how they're approaching the issue. So she's got it listed there. Everybody agree with what the staff recommends? Yeah, okay. Okay. That's number 9 is okay. All right. Commissioner Gavin, are you finished? You got some more?
Go ahead, Stan. I do got some more.
Number 22, the council reached out to complaint to see if there's been any update on Tyler refund status. And
I reached out to the complainant multiple times and they didn't get back to me, so I just didn't have an update on if that's been resolved or not because they're not responding to me. So it's a little hard to move forward when they don't answer. I can double check that they were sent the bond information because usually centralized does that in title issues. I can check that right now and then let you know.
Because if the complainant don't respond and give you the proper information, it's really nothing you can do unless it's really blatant a violation of the.
That's correct.
Correct, yeah. If we don't have the proof without the complainant, we can't prove the violation. So now there are times when even if the complainant doesn't comply or want to cooperate, we already have what we need. But this just isn't a case like that.
One last one, number 39, similar to the previous one. File.
Turn your microphone on, please.
Button.
There we go. How's that better? So this is a similar case than previous, where it doesn't illustrate whether there's any documentation have been seen to whether the vehicles were owned by the individual or were they open
They're
titles.
owned by the individual. Sorry.
They were,
I
okay.
apologize. Yeah,
Okay.
I'll include that going forward. But yes, they
That-
were.
yeah,
I
that's-
checked from both of those.
Okay. All right. Good. Thank you. That's all I've got.
Checking right now to see if 22 was sent the bond information.
Any more from the commissioner? Any more about the report?
They were sent the bond information on 22 also. Chris just confirmed that. Yes, and then I know 86,
Brought up.
yes, was a question.
I got it. I got it down.
So I wanted to see if you wanted to discuss that one, if whether or not that was misuse of the dealer's plate. So I'm under the understanding that they can let someone use it for 72 hours, and we don't have the exact amount of time that they had it in the complaint or response, but it appears that they probably had it longer than that just due to they had it during the delay of waiting for the title from the auction, but I'm open to what your thoughts are on that one.
Well, I don't think that, assessing a civil penalty should be done.
We can do a letter of warning, just kind of
Yeah.
instructing them of
I would.
the rules regarding that issue. Okay, I'll make that change.
Commissioner Jackson, that was my concern too, because I was looking at, they had no violation. They opened, looked like they licensed in 2019, but I noticed and they've been there 5 years with no violation, so I thought they had a pretty good record, so I was concerned about that too.
I'm just happy we cleared that up. In light of the fact Shelby County's 4 months, 5 months behind on the clerk's office, I was under the understanding that we could not, after the transaction happened, that we could allow to place a red tag on the vehicle after the customer already bought it. But I'm glad that came up. It gives me a new light on resolving our issues in Shelby County. You'll be able to see a whole lot more red tags running around Shelby County now.
But you assume the liability.
So, well, yeah, make sure the consumer has insurance. But yeah, I'm glad we cleared that up. Thank you very much.
Okay.
Commissioner Jackson, what's the final verdict on 86? Was it 86 we just speaking of?
Yes, 86.
Letter warning? Okay.
Okay, I made that change on there.
Very good.
I had number 94. Let me find it right quick. Let's see, 94. Opposed it. I think my concern was the $2,750 fine. I'm hoping I'm looking at the right one.
94 is a represent where the owner of the dealership has passed. So
Okay.
I was recommending to close that one.
I did have a
My
question.
question, Commissioner Jackson, my question is that the authorized civil penalty, the amount for failure to have appropriate business hours and issuing a temporary tag on a salvage vehicle. I understand the salvage vehicle, that's extremely dangerous.
That was the previous recommendation.
Okay.
The new recommendation is to close it since they have passed.
Okay.
Yeah,
But my
that-
question was, why was the fine so high, $2,750?
This was somebody else's complaint before it got to me, so
Okay.
I was not present when this decision was made.
maybe I ask my colleagues, is that a norm? Is that for salvage, what they allegedly violated, the salvage and the business license and the temporary tag, is that a normal high fee for that 2,000?
That's a pretty serious
Serious
combination
offense. Okay.
combination there.
Okay.
I could see that being that. But on that particular case, 94, I would have a question for the staff. Do we verify that this individual actually passed?
I spoke with their parents and with his mother, and they.
Really wouldn't lie, but I'm just curious if there's a protocol for that.
And previously, me and both my paralegal had spoke with him, and he was having a lot of medical problems that
Okay.
we had verified, and then his parents had to update us that he had passed. And
But that was the thought. You know.
I could look for his obituary.
I just
but-
didn't know if there's a protocol, for a pretty hefty fine, that'd be
Yeah.
an easy avoidance.
Yeah.
Mm-hmm.
Okay.
And if I can interject for just a minute, what I will do at the conclusion of our meeting today is, because it's been some time and I don't remember, I will email everyone the fine schedule that we
Right.
had come up with and approved so that you guys can look at it and refresh your memory.
And just to clarify, so it was $250 for the business hours and then $2,500 for the temp tag on the salvage vehicle.
Salvage.
That's what I thought.
Our set.
That's our set standard penalty anytime that happens.
Thank you.
Commissioner Galvin, just one more. On number 34, you had a respondent that had two salespersons with operating under expired license that you could not get the respondent to respond back to you, and there's a civil penalty of, I believe, $1,000. My question is, how long does this guy have to get back to the commission before we go to another step or we make this thing?
For an agreed citation, I believe they give him 30 days to respond.
He
think
agreed,
so.
he disagreed with the fine.
He didn't respond to
He
the
didn't
agreed
respond at all.
citation. And then he didn't respond to the complaint, and I believe they have 15 days before it's sent to us from centralized, and then we've had it, and they've never responded. So
If he
it's
doesn't
been-
respond after the 15 days, do you guys send him another letter out, or what's the next step?
So the next step would be us presenting it to you and asking for authority to issue a consent order. And if they don't sign the consent order within 30, 45 days, we can file a notice of hearing and charges and have a formal hearing, and they can't escape that. And if they didn't show up, we could default.
I just
So,
want to make sure of this, Apparently he don't care.
yes.
Yeah. So if they don't respond, they have 30 days from the consent order sent to them to respond. If they don't answer, then we'll move forward with filing a notice of hearing and charges.
Verify it's 15.
Sorry, from when the complaint is open in the centralized complaints, they give them 15 days to respond before they send it over to us for a response. And then, once I send, I'm sorry? 30 days from the. Yeah, then once I send the consent order after this meeting, they have 30 days to respond to me for that. And then if they don't, then I'll file a notice of hearing and charges.
Just for clarity, and staff may could ask this, on 51, just got a question. What does OEM mean?
I didn't Google that, but I figured it was just a type of tire since.
Original
Okay.
equipment from the manufacturer. Uh-huh. You know that one, don't you?
I figured that y'all would know it. I didn't think it was pertinent, so.
Well, I do a lot, because I really enjoy this, Commissioner, and I've learned a lot since I've been here, and when I see something that I don't know what it is, I'm going to ask that question. But again, great job. And does the Commission have any more question on any?
Commissioner Kramer, I do have one quick question. I noticed in reading number 73 that the complainant on the first case there was a lender. Do we have any jurisdiction, or do you all have any jurisdiction to complain about lenders?
No, we do not regulate lenders whatsoever.
I had. With that said and done, don't have any more questions to the staff in reference to the motor vehicle legal report. With the suggested additional on the different ones, do we have a motion to adjourn subject to the full commission?
So moved.
Do I have a second?
I'm sorry, can you officially go back through your motion to adopt the legal
Okay.
report as amended?
Number 6,
No,
they
no, you don't have to go through all of them, just, if you'll just say, do I have a motion to adopt the legal report as
Do I
amended?
have a motion to adopt the legal report as amended? All right, all those in favor of the motion, signify by saying aye.
Aye.
Any opposed, ayes have it ordered. We'll declare it closed at, what I got, 8:55 a.m., what a record.
We'll
Thank you.
reconvene at the,
Staff did a
at
fantastic
9:30.
job.
This is the regular quarterly meeting for the Motor Vehicle Commission. And before we get started, I just want to make a couple of comments and introduce Eleni Speaker. She is the manufacturer's rep for Nissan. Glad to have her with us. And also, Bob Weaver, you know what Clay Watson's update is. Would you like to share that with us? Right. Executive Director Lawrence, would you call the roll?
Yes, Mr. Chairman. Commissioner Barker
Present.
is present. Commissioner Elam
Present.
is present. Commissioner Evans is present. Commissioner Galvin
Here.
is present. Commissioner Jackson
Present.
is present. Commissioner Kramer
Here.
is present. Commissioner Levy
Present.
is present. Commissioner Lee is absent. Commissioner Melton
Present.
is present. Commissioner Norton
Here.
is present. Commissioner Speaker
Present.
is present. Commissioner Vaughn
Present.
is present. Commissioner Watson is absent. Commissioner West
Here.
is present, and Chairman Roberts. Mr. Chairman, you have a quorum.
Okay. Meeting notice.
Yes, Mr. Chairman, this meeting's date, time, and location have been noticed on the Tennessee Motor Vehicle Commission's website, including as part of this year's meeting calendar since November 12th of 2020. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission's website since July 18th. This meeting has also been noticed on the tn.gov website.
Right. We need to adopt the agenda for today.
Jackson motion that we today's agenda.
Commissioner Vaughn.
26, 22.
Commissioner Vaughn, second.
Any further discussion? All those in favor say aye. Aye. Opposed? We can do that by plural. Okay. Everyone got the minutes from the April meeting, and what's your pleasure on the minutes?
Motion to adopt the minute.
All right. So, comments, all those, I guess we need to roll call that one.
Yes, sir. Commissioner Levy? Yes. Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Speaker?
Aye.
Votes aye. Commissioner Melton? Aye. Votes aye. Commissioner Elam?
Aye.
Votes aye. Commissioner Barker? Aye. Votes aye. Chairman Roberts?
Aye.
Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Vaughn?
Aye.
Votes aye. Commissioner Jackson?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. And Commissioner Evans?
Aye.
Votes aye. You have voted to adopt the minutes.
Hey. All right, we'll go right into salesperson dealer appeals. And you want to address us on that, Erica?
Yes, we can start with Mr. Billy Marks. He's here. Okay. You can go ahead and come up, but I'm just going to say a few things. So, Mr. Marks has applied for a dealer license, which we have denied based on multiple reasons. So I'm going to try to summarize those for you as best I can. First off, the commission may deny an application for a license if any manager, director, or owner of 5% interest or greater could be denied licensure as an individual pursuant to TCA 55-17-114. So we denied Mr. Marks based on the fact that as an individual who would be owning this dealership, he can be denied a salesperson license or any kind of license, and under 55-17-114. So the reasons that he can be denied under 114 are the following. Mr. Marks was a partner of a dealership back in 2008 that we revoked their license, their dealer license, for fraudulent business practices. And for that reason alone, we can deny a future application. Mr. Marks did not include that information on his current application. He stated that he did not ever have any prior interest in a dealership, and therefore, of course, there was no discipline in his history. Additionally, we can deny Mr. Marks based on the fact that he has lied on multiple applications for the reasons I just went over, as well as on the most current application, Mr. Marks uses a date of birth with a month and day the same, but the year is different. He's put 11/29/1984 on this current application, whereas on past applications for salesperson in the prior dealership, he used 11/29/79. Through our investigation, we realized that Mr. Marks also has 2 driver's licenses with these 2 birth dates, so we find it hard to believe that that was just a simple mistake. We feel like that was a deliberate lie. And then the most recent information that we received leads us to believe that Mr. Marks is currently involved in a dealership at the same address that is at the new dealership that the application we just denied, that he's involved with the old dealership that was at that address. Their license just expired in June. We have at least 7 open complaints against this dealership that have not been replied to, and most of them are about customers purchasing vehicles and not getting their titles or registrations. Nobody's communicating with them. They can't collect on their surety bond because from the information I've received, that bond was canceled some time ago. And 6 of those complaints mention Mr. Marks as holding himself out to be the owner of this dealership. So what it seems like to us is this dealership let their license expire. We also know they filed for bankruptcy. We sent an investigator out there. They cleared the lot out. There are 2 civil warrants on the door. From what we've been told, they're underwater with their floor planner, and that could be what the civil suit is about. It has Mr. Marks' name on that notice on the door, as well as the owner, and the sign has been replaced with the new dealership name, which is the license we've just denied. So for all of those reasons, we feel like it is appropriate to deny the dealership license.
Wow. Mr. Marks, would you like to address us on?
I'm going to clear up a couple things for you guys. Please speak into the microphone.
Okay, is that better? Okay, so I will clear up a couple things. The first thing is the date of birth. I can show you guys my driver license. Back when I had the dealership back in 2008, my date of birth was 79, and that was due to the fact that I did not have my birth certificate. Whenever I did from Kentucky, originally when I got my license, I got it from baptism papers, all I had. So apparently the church messed up on the date of birth. They gave me the wrong year, but the right birthday. So my driver's is fixed. It's been fixed for quite some time. So that was the reason for the date of birth change. I only have one license. And then as far as the license being revoked for cars under 3,000, I have a letter here from Aaron Rochelle that we have turned in our license. It did not get revoked. And it's from his email. Let's see, it was exactly on June 18, 2009 at 1:55 p.m. is when he wrote it. So I do have that as far as the old dealership. The dealership she is talking about belonged to my wife, and she did not run it properly. Everybody thought I owned it. I did not. That was my wife's car lot. The only reason I am trying to open it is because we still have an outstanding lease on the building, and no matter what, they're going to still charge us for it anyway, so I might as well go ahead and try to open up a dealership and try to do right. Last dealership I ran was cars under 3,000. We had issues because of Frank Marks. He was my partner. He was going through a divorce, and we was having issues back and forth with his wife calling to the state and complaining and whatnot. Her dad was a motor vehicle attorney, motor vehicle in Florida, so he kind of knew how to hurt him. I'm not trying to discredit anybody. I'm not trying to scam anything. I'm just wanting to run a legitimate business, and I'm not even looking for a floor plan at this point. It is basically wholesaling cars and a few cars that'll retail, not much. I was promised by Aaron Rochelle in the email that we would have a fair shot at opening up a new dealership. Now, as far as my wife's dealership, our attorney is the one who reached out to all those clients, and that matter is being solved. So there shouldn't be any issue. He's the one who's supposed to be responding to their emails or whatnot. He's supposed to handle it all. That's something that I can't speak on because it's not my dealership. It is my wife's, but I did not know anything about people writing complaints. I mean, it's not something I do, but I was at the dealership time to time, you know, picking up mail, checking over the employees, paying the employees for her, that kind of stuff. But I was never running the dealership, no. Everything ran through Pebble Williams.
You bring anybody with you?
No, my attorney could not be here today.
Okay.
I tried to. He spoke to the young lady, what was her name? Laura, I think. I don't know which one's Laura. He spoke to somebody here and told him he was trying to get a later time. He couldn't be here till afternoon, and that couldn't happen, so he couldn't be representing me. So I wanted to try to come and, you know, show you guys I don't need an attorney. I have nothing to hide. So, I mean, I'm just trying to run a legitimate business, and I don't think I should be denied for that. I should be given a second chance. I didn't do anything wrong the first time. Now, if you guys look at all the complaints, that was towards Frank Marks. Frank Marks did have a lot of complaints. That was my partner, unfortunately. At the end, before we even turned in the license, I was signing off on that dealership anyways because I was getting out of it. I was selling it to him because I did not like him as a partner. Basically, in a short story, I learned not to do business with family.
Questions from?
Real quick.
sir.
What? Oh,
Commissioner.
sorry. Go ahead. Nate.
Commissioner Jackson, I'm looking at this document it's the Tennessee Motor Vehicle Commission appeal request form. And I guess it's on page 2 in our pad. And I'm looking at the type of license, dealer license, and the number 16582. Kidney staff, is there any kind of way you can pull that up and see who was applied for that dealer license? And then I read on a further, my license was not revoked. I volunteered to turn my dealer license years ago. I worked at cars under 3,000, my salesperson license number so-and-so. I'm just curious about where this number, this 16, whatever number that is, who actually opened that first dealership? I'm curious on that one. If I can get that, then I can kind of move a little further with some more questions.
I actually got that dealer license.
I'm talking to the staff, sir.
Oh, sorry.
I want it from the staff.
So that number is the license number for the prior dealership that Mr. Marks has mentioned called Cars 3000 and Under. And that is the dealership where we have a signed consent order for voluntary revocation. We call it voluntary because we wanted to revoke the license, and they did. They accepted that revocation and turned it in instead of having a formal hearing to revoke it. That's the only reason we use the word voluntary. It's still a revocation.
Second question is, does the record indicate that his wife owned a dealership?
Yes, the record indicate. Well, I did not know that Miss Williams was his wife, but we suspected that. But yes, the record indicates that Miss Pebbles Williams owns the dealership at the location where Mr. Marks is trying to open the new dealership. Their license just expired, and they have a lot of open complaints that mention Mr. Marks.
So the multiple complaints, wife dealership
Yes, but they specifically mention his name.
name.
Yes, as being the person who answered the phone calls about the delays and gave reasons for the delays.
Because I heard him admitted that he was working at his wife's dealership, phone call and signing off all kind of document. Now, my other question, did he have a salesman license during that time? Can you check the record to see if he had a salesman license?
No, he's been denied a salesperson license in
Okay.
the past.
So he should have not been at that dealership signing off on documents of selling cars and all that.
If that's what
Because
he was
didn't-
doing, yes, he should not have been doing that.
Okay.
Mr. Marks, what you may have said it, Mr. Marks. What was the relationship with Frank Marks? How are y'all related?
It's my first cousin.
Okay, you might have said that and I missed it, but I knew.
And just to clarify on that, I did not sell any cars at the dealership. I did not sign any paperwork. I was signing off on paychecks to employees that was running the dealership. And I was going over stuff with the salespeople. I'd never sold a car there. Now, people that might have heard my name from the salespeople, that is possible.
Yeah. Is there any record that showed that he may have, and you may not have this, I'm just asking the question because he's leading me into what he just said. Is there any information that verified that he signed off on any salesman of a car during that dealership, at that dealership?
Unfortunately, at the time we got these complaints, they had already closed. So when we sent an investigator out, we couldn't look at anything. I just know that there's at least 6 complainants that mention not just him, but they say that he's the owner and he held himself out to be the owner. Those are their words. And these people are not related in any way. They're separate complaints at separate times.
All these complaints was back in 2009. I think that's what I read.
Well, there were complaints that led to the revocation of Cars 3000 and Under. That started in 2008. I believe it was revoked by 2010. And then the open complaints that I'm talking about with his wife's dealership all started mostly this year. Although there is a disciplinary history that goes back a couple years where they didn't pay off a vehicle and they paid a civil penalty and signed a consent order. His wife, not him. And then that also, I don't know if I mentioned, but along with the no titles and registrations to these consumers, there's also continuing allegations of not paying off trade-ins.
Commissioner Vaughn, one more question. So you did say that you and, what was the other person's name, were
Frank
partners?
Marks. Yeah, we was partners.
Okay.
Commissioner Galvin, you mentioned that you didn't have a salesman's license, but you signed paychecks.
I was writing paychecks out of the bank account for the employees.
Signing paychecks.
I went whenever she couldn't go. She had another job as well. That's why she had full staff employees there. So if on a Friday or whenever the payroll was, I forgot if it was Mondays or Fridays, but if she wrote checks, I would drop them off, or if she didn't write them, then I would write out their checks and give them to them because she wasn't able to make it.
Okay, and you ever arrested before?
I was arrested,
Can you talk
not
about
convicted.
that incident, please?
What'd you say?
Can you talk about that?
Yeah. What would you like to know? It was expunged. It was in Gallatin. That charge was because of my wife as well. It was for a business that she owned. And a gentleman thought he was entitled to a refund, which was not. We actually won the case, so that's why I said it was expunged.
Mr. Jackson, did not you think it was important to have your wife here to kind of explain all of this? Do you not think that was important?
I really didn't think that was a big issue on this one. When I spoke to the people that I did, they said bring the letter in and that I would have a chance on getting my license. I didn't even know this was an issue.
This is Commissioner Vaughn for discussion. This is something I'm extremely uncomfortable with. I don't believe what you've said. You should have brought her with you. This is a very serious matter, and we take this very seriously. No, I'm still speaking.
I'm sorry.
This is something to me that it is our duty to protect the citizens of the state of Tennessee, and there's no way I would approve this license personally. So I make a motion that we uphold the denial.
Commissioner Jackson, second it.
Further discussion? Executive Director Lawrence, will you call the roll on this vote?
The motion made by Commissioner Vaughn is to uphold the denial, seconded by Commissioner Jackson. Commissioner Levy?
Aye.
Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Speaker?
Aye.
Votes aye. Commissioner Melton? Votes aye. Commissioner Elam?
Yes.
Votes aye. Commissioner Barker?
Aye.
Votes aye. Chairman Roberts?
Aye.
Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Vaughn?
Aye.
Votes aye. Commissioner Jackson?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. And Commissioner Evans?
Aye.
Votes aye. The denial has been up.
Mark, sorry we couldn't help you.
Question. If I wanted to reappeal and have my attorney here, is that a possibility?
I mean, typically, an appeal is the appeal and it's final. I mean, I suppose you can go through the entire process again of making application for licensure, and we can approve or deny that license, excuse me, and then you could appeal again, but I'm not sure that that would do much good.
Just talk to your attorney to see what your legal options are to
Right.
appeal this decision.
Appreciate it, guys.
Ilya Bice? Erica, would you like to give us some background?
Yes, thank you. Ms. Bice has applied for a salesperson's license, and that application was denied based on the fact that Ms. Bice has been convicted of a crime of moral turpitude, and fewer than 5 years has passed since she has finished her her parole, I guess. Is it parole or super? Okay. However, so the crime is conspiracy to manufacture and sell methamphetamine, but that crime occurred back in November 2006. Now, the judgment mentions it was through 2012. I'll let Ms. Bice answer any questions you have about that, but as you can see, it's been some time. Ms. Bice was sentenced for that crime in June of 2014. It's a Class A felony. However, she will be done with her parole in October of this year, and we do have a letter from her parole officer. Is that okay? From the parole officer, and she states that Ms. Bice has been on probation since June 17th, 2014. During her time on probation, she has been in compliance and in good standing. She is set to expire from active supervision on October 21st, 2022, and then they provide their number if we have any more questions. So that is some evidence of rehabilitation, that I would call it. So yes, there is a discretion. You have discretion to deny if you would like to uphold that. And I'll let you talk to Mrs. Bice.
Would you like to address this? And
That was a completely different time in my life. It's still sometimes hard for me to believe that that was me, but it was, and I accept, responsibility for that. Since then, I've done, quite a bit for my community and helping. I don't know anything more than to say I feel like I keep getting punished for this. In a way, I deserve it. In a way, I want to move past it. That's all for now.
did you bring anybody with you that would like to speak for you?
I'm Vanessa Sewell. I'm the CEO of Battle Creek Power Sports, and Missy has worked for me for 3.5 years now, and she is just a pleasure. If you wonder whether people get through a rough time in their life and really win, she is an example. She has gotten her kids back. She has gotten her driver's license back. She is an absolute bastion in our dealership, and we've had her in parts and service for 3.5 years now. She does anything. If the alarm rings in the middle of the night, Missy answers it, not even me. I don't drive 35 minutes from Chattanooga. She drives 7 minutes to make sure that my assets are being taken care of and covered, and meets the police there. She takes the bank deposits. I mean, sometimes we're handing off, dozens of thousands of dollars in cash, and Missy's the one that takes them. I'm sorry, Amelia is the one who takes them to the bank. So as far as trusting her, none of her, her crime was never anything that was to defraud other people. So I don't worry about myself, my own assets, my dealership. I don't worry about my customers, and they love her. Amelia is not only someone who is compassionate with the customers, she really knows what a lot of them have been through. So she is truly, when sometimes our friends who work with recidivism get down about how it seems that people don't always win, let me tell you, she has really turned her life around and is just amazing. So we would be very honored at Battle Creek Power Sports to have her as a salesperson, and I greatly hope that you will approve that.
Commissioner Vaughn, I have a few questions for Ms. Bice. And I always ask the same questions. Have you been in trouble since this occurred? Have you made restitution of any type that you are required to make?
Of restitution, and so I did get about a year, maybe not even a year, I got a DUI. That's when I went to jail and was like, had to see my kids through a glass. So I checked myself into rehab the day that I got out, and have not gotten in any trouble since. I didn't have restitution, but I am up to date on my fines and stuff.
Bice, are you currently enrolled in any recovery programs or continuing?
Yes, I go to 2 meetings a week. I also help we had a chaplain in jail, and they kind of gave him a pushback inside of the jail, so he started doing quite a bit outside. So when people get out, he has like anger management, and a lot of these people don't even have like proper hygiene when they get out. So I, with the help of Vanessa, make baskets, and so many for men. I make a couple for the kids. So when they get out and they can go to him, he tries to help them like find a job and stuff. So I help him, and I make the baskets.
Mr. Jackson, I motion that we grant her the license.
Second, Commissioner Vaughn.
Okay, Executive Director Lawrence, will you call the roll for this vote?
The motion is to approve licensure. Commissioner Levy?
Aye.
Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Speaker?
Aye.
Votes aye. Commissioner Melton? Aye. Votes aye. Commissioner Elam? Aye. Votes aye. Commissioner Barker?
Aye.
Votes aye. Chairman Roberts?
Aye.
Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton? Votes aye. Commissioner Vaughn?
Aye.
Votes aye. Commissioner Jackson?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. And Commissioner Evans?
Aye.
Votes aye. You have been granted licensure, and just to let you know, we will email that to you today so that you can go ahead and get started. And congratulations.
Very grateful.
Thank you. Okay. Executive Director Lawrence, will you give us your report?
Now on to the director's report. We have had a very, very busy last 3 months. If you look at the document that you were sent, we've had 65 new dealers opened and 29 in process. Barry was just telling me a while ago, we run the gamut now. We've got Maserati, Ferrari, Lamborghini, so everybody is coming to Tennessee, and we're excited. One thing that we failed to do was to include in your packet the disciplinary action report, but we have received $15,100 over the last quarter for in the form of consent orders, etc. We will get that document sent to you as soon as we adjourn today, and I'll send you the citation schedule as well so you can look at that. I wanted to mention that we actually lost an employee last year, and so we went through this very long process of interviewing, and we found this great guy, and he came to work for us, and he worked, I think, 2 days. And because my team is so incredibly professional and efficient, they said, we don't think you need another person. And so I lost that person because there was another program who that was suffering greatly. So we took it on the chin, but everybody on our team has pitched in, and our numbers continue to far exceed any other program in the department. So I'm extremely, extremely proud of them, and I'm honored to work with them every day. Last week, we did an outreach event with the mayor of Bledsoe County. Actually, Jason handled that for me as I took a little unexpected trip to the beach. And he was able to relay to the mayor of Bledsoe County, exactly what we do, what the commission does, what our mission is, and then gave him the number of licenses there in the county. I think he was really surprised. And I think Jason told me he was a former car dealer. Had been in the business in a former life, so he was very familiar with it and was pleased to hear from us. So we're going to continue to try to do things like that. Upcoming in September, we are going to play a pivotal role in NAMBIC. That's the National Association of Motor Vehicle Boards and Commissions. They have their annual convention here in September at the Opryland Hotel. So we're going to be there and hope we can make some good connections. Things have been put on hold because of COVID. So this is the first time that that's happened. Lastly, Jason and I went to the County Clerks Convention in Gatlinburg back in May, and that was a very successful visit. We got to see a lot of people that we haven't seen in a long time, county clerks, and make some new friends. And that was, I've continued, literally after we got back, I must have gotten 10 emails from different county clerks saying, oh, can you tell me what you were talking about? So we've been really, really busy, and we hope to stay that way. But that's pretty much all I have in the way of a director's report.
Okay. We have a motion to accept the director's report. Further discussion, Executive Director, if you will call the roll for your report.
The motion is to adopt the report made by Commissioner Jackson and seconded by Commissioner Barker. Commissioner Levy?
Yes.
Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Speaker?
Aye.
Votes aye. Commissioner Melton? Votes aye. Commissioner Elam? Votes aye. Commissioner Barker?
Aye.
Votes aye. Chairman Roberts? Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Vaughn?
Aye.
Votes aye. Commissioner Jackson?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. And Commissioner Evans?
Aye.
Votes aye. You have adopted the director's report.
All right. But I understand there's, we need to do the legal report.
Yes, thank you, Chairman. We've just got 4 amendments to the recommendations, so I'll just go through those real quick. Number 5, we have changed the recommendation to a letter of instruction. Number 7, we've changed the recommendation to a letter of warning instead of a civil penalty. Number 49, we have also changed that to a letter of warning instead of a civil penalty. And finally, number 86, we have changed the recommendation to a letter of warning instead of a civil penalty. And that concludes all of our changes.
Of a
Commissioner Jackson, motion that we're
Commissioner Vaughn, second.
discussion. Executive Director Lawrence, will you call the roll?
Motion is to adopt the legal report as amended. Commissioner Levy? Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Speaker?
Aye.
Votes aye. Commissioner Melton? Aye. Votes aye. Commissioner Elam? Votes aye. Commissioner Barker? Aye. Votes aye. Chairman Roberts? Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Vaughn?
Aye.
Votes aye. Commissioner Jackson?
aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. Commissioner Evans?
Aye.
Votes aye. You have adopted the legal report as amended.
All right. Legislative updates. Who's presenting that?
I don't think we have any legislative
We don't?
updates.
Okay. Committees, we haven't,
No reports from
no
committees.
report there. And new business, I guess we'll have a hearing at 1.
Yes, sir.
Okay. So we'll just about changing the legal. We thought about changing the legal committee, going back to what we used to do and meet at 9 instead of 8:30.
We will do that going forward.
Okay. Y'all like that? Okay.
Definitely.
We're getting so good at this, you know,
They're
so
getting
efficient.
so good at
Yeah.
it. We don't, you know,
Let's
there's no
reward
questions.
everybody.
Oh, yeah. That's it. Do we need a motion to change it, or we can just take an action?
That's for the
Okay.
next time.
Okay. All right, so.
Credit that to the staff now.
Yes.
What's that?
We credit that to the staff for doing a
Oh,
great
yeah.
job with the
Yes.
reports.
Absolutely. So we'll reconvene at 1 o'clock?
At 1 o'clock here for the hearing that has been scheduled for this afternoon.
Okay. Yes.
Commissioner Norton, just want to make everyone aware of the fact that we're still continuing to pursue e-titling. I've been in contact with Alison Raymer, Director of Vehicle Services, along with Bob Weaver and Everett Signer, and they've given us their word they're going to continue to work on it. They say it's about an 18-month cycle to do the beginning stages. And I think we're getting good information out of that after a few phone calls. I just had an email from her last week. They had a setback. We were going to start in July, but I think it's going to begin in August, the initial stages. So we have that to look forward to. There's 23 states that are on e-tiling. We're not one of them, but I think we still pursue that for the obvious reasons to be relevant going forward to serve our industry and our consumers. So just want to bring that up. That's still on the table.
And I might mention, and I apologize, I feel like I'm jumping all over the place, but it occurred to me, I literally got an email yesterday, which was a legislative inquiry. So I wanted to make you all aware. The inquiry was relative to dock fees. And the question was, you know, is there a cap or a limit on dock fees? Where is that spoken to in the statute and the rule? And so that's an issue that may arise during the next legislative session. We just might want to be on the lookout for. It appears that someone was asking their state rep to cap dock fees. And I think we
We're
need
gonna-
a motion to recess.
Okay.
So moved. Commissioner Vaughn.
Okay. Any further discussion? All those in favor say aye.
Aye.
Okay. See you back at 1. All right, let's go ahead and get started. We'll reconvene, and this is my first time to ever do a hearing, so y'all have to help me through this. In the matter of Higginbotham Automobiles of East Memphis, LLC, DBA, Mercedes-Benz of Collierville, the petitioner versus Mercedes-Benz USA, LLC, respondent, TAG Truck Enterprises, LLC, and intervener, and APD case number 12.17-213712A. And I will now turn the meeting over to Judge Waterhouse.
Good afternoon, everyone. Can everyone hear me? Okay. Today is July 26, 2022, and this is a hearing before the Tennessee Motor Vehicle Commission. We are present in Nashville, Tennessee in person. The chairman already called the case and the docket number. My name is Rachel Waterhouse, and I'm the administrative judge assigned by the Secretary of State to preside over the hearing, sitting with the commission. The purpose of the hearing is for the Commission to consider an appeal from an initial order entered by another administrative judge dismissing this matter, which I will explain further to you in a moment. The issue as stated by Petitioner Higginbotham is whether the judge properly dismissed the protest stating Higginbotham did not have a right to protest the new commercial vehicle dealership license to TAG Truck Enterprise since the proposed dealer is located outside the relevant market area given to Higginbotham by Mercedes-Benz USA. I will make all rulings regarding procedural questions of law pursuant to the authority granted to me by the Administrative Procedures Act, commonly referred to as the APA. You okay? Okay. In other words, it is my duty to regulate the course of the hearing and procedural legal issues involved in the hearing. However, I will not participate in the Commission's ultimate determinations. And at this time, I would ask the commissioners to please introduce yourselves for the record. It's fine with me if we start on this end and go around the horseshoe.
Levy?
Charles.
Debbie Melton. Sandra Elam.
Eleni Speaker.
John Roberts.
Jim Galvin.
Stan Norton.
Sarah Vaughn.
Nathaniel Jackson.
Carl Kramer.
Victor Evans.
Thank you. And the commission is chaired by John Roberts. Mr. Roberts, do we have a quorum of the commission members?
We do.
Okay. And have all the members received the relevant documents from the technical record that it was transmitted before and had an opportunity to review them before the hearing? And if everybody would raise your hand if you can answer in the affirmative to that question. Okay, let the record reflect that everybody has received and reviewed the records that were transmitted prior. Now, at this time, I would like counsel to state your appearance along with your party representative or client. We'll start with the petitioner, then go to the respondent, and then go to the intervener. Okay, thank you. Just as a housekeeping matter, Ms. Lawrence, when it's time for oral argument, will the council use the podium?
Yes.
Okay. So everybody just make your way to the podium when it's your turn, and I'll let you know when that time is here. On March 21st, 2022, Judge Michael Begley ruled on the intervener's motion for summary judgment. Judge Begley found that there was no disputes of material facts presented and that the motion should be granted as a matter of law. Accordingly, Judge Begley dismissed the protest matter in its entirety in that initial order. The statute at issue in the initial order is Tennessee Code Annotated 55-17-114C20. This is an appeal by the petitioner Higginbotham of Judge Begley's initial order. The Commission conducts its review of the initial order in a contested case in accordance with the Administrative Procedures Act, which I will call the APA. According to the APA, when the Commission reviews an initial order, it must exercise all the decision-making power that the Commission would have had to render a final order had the Commission presided over a hearing or a trial. The Commission's review is de novo, and there is no presumption of correctness of the ALJ's order. The Commission has its own fact-finding authority and may substitute its judgment for that of the administrative judge. However, the Commission should not simply ignore findings of fact contained in the initial order. While a reviewing court must focus its attention on the Commission's final order, it may consider the initial order when determining whether the Commission's final order was sufficient evidentiary support. The Commission should expect closer judicial scrutiny of its findings of fact when it disagrees with an administrative judge's findings. The Commission's findings of fact must be supported in the record by substantial and material evidence. This reasonably sound basis must be explained on the record or in the final order. Material differences between the final order and the initial order that are not explained may be problematic on appeal. The Commission may accept Judge Begley's initial order in its entirety. The Commission may modify the initial order as it deems appropriate, or the Commission may reject the initial order and compose its own order, which will be named a final order after this proceeding. Because Judge Begley ruled on summary judgment, let me explain the summary judgment standard for you now so you have that in mind when you hear oral arguments of the council. Summary judgment is warranted when the pleadings, depositions, answers to interrogatories, and admissions on file, together with affidavits, if any, show that there is no genuine issue as to any material fact and that the moving party is entitled to judgment as a matter of law. And I will explain to you in a few moments what the evidence is in the record. I don't believe any discovery was conducted in this case prior to the filing of the motion. If the non-moving party's evidence at the summary judgment stage is insufficient to establish the existence of a genuine issue of material fact for trial, then summary judgment should be granted in favor of the moving party. Keep in mind it was Tag Trucks, the intervener who made the motion here, and is the moving party. The non-moving party is the petitioner Higginbotham. When considering a summary judgment motion, the evidence must be viewed in the light most favorable to the non-moving party. That means in favor of the petitioner Higginbotham, and all reasonable inferences must be drawn in the party's favor. When determining whether a genuine dispute of material fact exists in a particular case, courts must focus on whether the evidence establishing the facts is admissible, and there is admissible evidence in this case, which I will explain to you in a moment, whether a factual dispute actually exists, and if a factual dispute does exist, whether the factual dispute is material to the grounds of the summary judgment. For a fact to be material for summary judgment purposes, it must be necessary to resolving the issue to be decided. In other words, whether resolution of that fact will affect the summary judgment motion, or if it must be decided in order to resolve the motion. A genuine issue exists if a reasonable jury could legitimately resolve the fact in favor of one side or the other. Summary judgment should therefore be granted only if the uncontroverted facts presented and the conclusions to be drawn from those facts make it so clear that a reasonable person can reach only one conclusion. Commission members are reminded that during the time of this hearing, no discussion concerning the case should take place between commission members and the judge, attorneys, other commission members, or other persons unless all parties are present. During the hearing, commission members must only consider the evidence in the record. The Tennessee Sunshine Law or Open Meetings Act requires that all commission discussions and deliberations be in public before all parties. Failure to observe the Sunshine Law may result in the Commission's action being reversed or remanded if it is appealed. Commission members, you are reminded that the law requires you to disclose on the record any outside knowledge of this case or any communications, whether written, verbal, or otherwise, from any parties concerning this case. This does not include Commission business at a previous meeting on July 28, 2021, during which the Commission granted the petition for protest hearing filed by Higginbotham. I instruct you that you are not to give any consideration whatsoever to any outside knowledge or external communications about this case. This includes information and discussions at the previous meeting of the Commission to discuss this matter. Your decision must be based only upon the evidence in the record developed by Judge Begley. If any Commission members has any outside knowledge of this case or any communication with any parties concerning the case, then please raise your hand. Let the record reflect that nobody raised their hands. Commission members, you are also reminded that the APA requires you to disqualify yourself from participating in this hearing if you have bias or prejudice against one of the parties, a pecuniary or other interest in the business of one of the parties, or for any other reason that may keep you from being impartial in the proceeding. In other words, you must be able to give full and fair consideration to the matter without favor to one side. If any Commission member has any concern about the ability to disregard all prior information you have received, including items presented at an earlier meeting and discussions thereof, or concern about the ability to make your own decision in this case on the evidence already in the record only, or concern about the ability to fairly hear this case without bias, then please raise your hand. Let the record reflect that no member raised their hands. Before the hearing begins, I am going to give you some instructions to help you understand how the case will proceed today, what your duties will be, and your conduct during the hearing. Attorneys for each party will be allowed 30 minutes of argument, beginning with the petitioner. Then the petitioner will be allowed 10 minutes for rebuttal argument. The attorneys will use this time to point out to you what they contend the evidence shows, what inferences you should draw from the evidence, and what conclusions you should reach. After all parties have completed their arguments, then Commission members will have the opportunity to ask questions of the attorneys. Your time for questions should be used to help you understand the evidence in this case and assist you in reaching a decision. You should reserve any expression or opinions you may have on the facts until the portion of the hearing which is set aside for your deliberations. Questions that must be answered with information outside the record are not permissible. Statements made by the attorneys are not evidence. Their statements are made only to help you understand the evidence and apply the law to the evidence in the case. You should ignore any statement by counsel that is not supported by the evidence in the record. After the attorneys complete their summations, I will provide you additional instructions to assist you with your deliberations. You should consider the evidence and arguments of counsel with an open mind and not draw any conclusions until your deliberations. Next, we will listen to the petitioner's counsel, who will have 30 minutes for argument. Then the respondent's counsel will have 30 minutes for argument. Intervener will go next and have 30 minutes of argument. Then the respondent has an opportunity to also present 30 minutes of argument, and then the petitioner may, but is not mandatory, to present 10 minutes for rebuttal. And so with that said, then Mr. Cameron or Mr. Mason, you can begin.
Thank you, Judge Waterhouse. Thank you, Chairman and Commissioners, and also the Executive Director for being here today. My name is J.D. Mason with Jim Cameron. Again, we represent Higginbotham Automobiles of East Memphis. This case is before the motor vehicle after TAG's motion by the administrative law judge. Judge is here.
Hold on, Mr. Mason. That mic's coming in and out. We can't hear in this corner.
Now I did. Okay. In its ruling, the administrative law judge ordered that the commission does not have a right to hear the facts of a case whenever there is a dealer protesting the establishment of a new dealer if that new dealer is not within the relevant market area of the existing dealer. To be fair, this hearing today is not on whether the relevant market area and all the facts before us is to be determined. That'll be at a final hearing. What we are asking today is that the Commission have the chance to hear all those facts after discovery has been taken. As Judge Waterhouse mentioned, we have not done any discovery. We haven't taken any depositions or anything like that. And so we hope that the case is not dismissed on a simple technicality or a narrow interpretation of the statute. We believe that the commission is the sole remedy that dealers have in this state of Tennessee to bring actions against a manufacturer whenever the manufacturer to bring actions against the commission or against a manufacturer when the commission has an opportunity to hear all those facts, and we want that opportunity today to be able to move forward and go to a final hearing. First, let me explain what the legislature and the courts have said about the commission's role in regards to disputes between manufacturers and dealers. The commission has granted all of its authority through the legislature itself. This is important because time and time again, whenever disputes come up between manufacturers and dealers, the manufacturer has always tried to restrict the commission's authority to be able to hear these facts. Not just when a manufacturer attempts to restrict the commission's duty to be able to hear all the facts before it, but also we need to be able to keep in mind the statute's clear and significant intent and purpose is for the commission to do its job and to hear all the facts before it. Since 1983 in the Capital Chevrolet case, when disputes arise between dealers and manufacturers, the manufacturer has always attempted to restrain the commission. This case is no exception when even the courts have continuously upheld the rule of law and states that the commission does have the authority to hear these types of cases. In the Tennessee Supreme Court case of Capital Chevrolet, it's important to note that there's a very similar argument being made. In that case, there were 6 dealers protesting the establishment of a new dealership. Now, of course, all 6 of those dealerships did not encompass the new ad point within their relevant market area, but the commission found and the Supreme Court of Tennessee held that there is a pecuniary interest for all 6 of those dealers to hear this protest, because it's not just about what the relevant market area is or what it is defined by the manufacturer in the franchise agreement, but it also needs to take into consideration the pecuniary interests of the market as a whole and how well these dealers are representing and servicing those customers in that market. In the Jim's Motorcycle case, that's a Court of Appeals case here in Tennessee, it restated that the Motor Vehicle Commission has the exclusive right to be able to hear the facts of a case and determine in a 3-factor test what the relevant market area is for the protesting dealer, how well that dealer is servicing that market, and as well as what proprietary interests they have in continuing to operate in that market. TAG will argue today, I say TAG, that's the intervening party here. TAG will argue today that the Jim's Motorcycle case is completely different from our facts because they did not specify a relevant market area in the TAG, in the Jim's Motorcycle franchise agreement. But I want you to pay particular attention to if TAG or Mercedes-Benz today introduces a franchise agreement with my client Higginbotham identifying the relevant market area of Higginbotham. I'll tell you, there is none. It's not in the record. Even the Jim's case shoots down TAG's argument as to when you need to be able to read the statute and read all the words in the statute. And I want to quote you a line from the Jim's case today. It's, statutory words are known by the company they keep. Courts must also construe these words in the context in which they appear in the statute and in the light of the statute's general purpose. And that line I want you to just keep in mind as I speak here today, because that's going to keep coming back to what our sole purpose is to make sure that the statute is read entirely. The legislature in Tennessee Codes annotated 55-17-114 C20, I apologize, that's a mouthful. It says that it defines relevant market area, but then it goes on to discuss dealers in the area. And it says that if you're a dealer in the area, you're required to get notice of an ad point from the manufacturer. And the difference is significant and important in the sense that dealers do not need to be in their own relevant market area to protest an ad point. The new dealer the protesting dealer can also push towards the commission and fight against that new ad point if it's going to be inequitable to the existing dealer or if the market is already being serviced by the existing dealers in the area. The Hyundai Motor America case is another case that we have before us today. In that case, it's almost identical to one that we have here in the facts of this case. That was a 2016 opinion of the Court of Appeals in regards to an ad point in Knoxville, Tennessee between Grayson and Twin City Hyundai. In that case, Hyundai moved to dismiss the case because the new ad point was outside of Grayson and Twin Cities' relevant market area. But the Court of Appeals said that even though it's outside the relevant market area, they have a right to be able to hear the case because the Commission and the Court of Appeals, the Commission itself is not looking just at what the relevant market area is. It's a three-factor test. What's the relevant market area, the adequacy at which the current dealers are servicing that market, but also the proprietary interest that existing dealer has in keeping that market alive. Given the posture of the case today and the lack of discovery conducted by the parties, we would ask just for ample time to be able to conduct that discovery before this case is dismissed on a technical reading. In this case, the only Mercedes-Benz dealer in all of Shelby County is Higginbotham. Higginbotham was appointed by Mercedes-Benz in 2014 to be a commercial van franchise. Now keep in mind, this is a commercial van franchise. This isn't your typical automotive dealership. It's just for the van franchise. But with the dealership and the agreement with Mercedes-Benz, that allows them to sell two different models of this particular van. It allows them to buy parts directly from Mercedes-Benz. It allows them to service warranty work for Mercedes-Benz, and it also allows them to conduct or be involved in the auctions directly with Mercedes-Benz. We sold and built our customer base throughout Shelby County since 2014, and that has continued to grow. And we weren't doing it by ourselves. We were doing it with Mercedes-Benz. Mercedes-Benz was telling us time and time again that we are the exclusive commercial van dealer for Mercedes-Benz in Shelby County and all. These are the facts regarding how the business has evolved over the last 8 years that we believe the Commission should have an opportunity to hear at a final hearing. TAG, on the other hand, was a Freightliner dealer. TAG sold one line of the Sprinter van. We were selling two. TAG was selling one that was substantially similar or the same to the one that we were selling. But they weren't able to buy the parts from Mercedes-Benz. They weren't able to do the warranty work for Mercedes-Benz, and they weren't able to advertise as a Mercedes-Benz dealer. A few months ago, Daimler, Mercedes-Benz parent company, decided that they weren't going to move forward with the Freightliner franchise anymore, and they started winding that business down. As we speak here today, a bunch of Freightliner dealers are suing Daimler for that exclusion and removing those Sprinter vans out of their business. In the instance of TAG, however, Daimler, Mercedes-Benz, and TAG agreed to give TAG a franchise for the commercial van dealership. Tennessee law requires that a manufacturer, when adding a new dealership, notify not only the existing dealers in the area, but also the commission itself. We would say that we have not seen this notice being filed by anyone, whether that was through us or through the commission. We found out about it through word of mouth that they were adding this new ad point, and we filed our protest, which is how we got before you today. Before you've had a chance to hear all the facts of this case, TAG filed the motion for summary judgment, stating that there was not a right for us to protest through a very narrow, restrictive interpretation of the statute. The ALJ agreed with Mercedes-Benz, and now it is before you to decide if you want to hear all the facts. The Act permits a dealer, upon an initial ruling, as Judge Waterhouse mentioned, that we are able to appeal directly to the commission, and that's what we've done today. We believe that it is ultimately your decision to hear all the facts of the case before determining what the relevant market area is for Higginbotham and how that market area has changed over the last 8 years since we were first appointed a dealer. The commission has a right and duty to hear all the facts of the case and not permit this to be dismissed on a technical reading of the statute. First, the statute is clear. Again, TCA 55-17-114C20 walks the commission and anyone reading it through how it's supposed to be read. It starts with defining the relevant market area, and then it goes into what dealers can protest. And if they are a dealer in the area, they are to receive notice and they are able to protest that ad point. Because once the protest is filed, it's up to the commission not only to determine what the relevant market area is, but they also have to decide whether the existing dealers are servicing that market and also whether there's any propriety interest in that existing dealer maintaining that same market. It's important to keep in mind that the commission itself can file this protest even without the dealer's involvement. Of course, the commission doesn't have any relevant market area in Memphis, but they still have that authority to do so because that's what the statute says. And the statute says that we are able to protest this addition of a new dealership as well. On the Court of Appeals case of the Hyundai matter, this is the Jim's motorcycle case, the American Honda case. The court has already stated that you cannot stop reading the statute after the word provided. You have to read relevant market area, semicolon, provided that if a dealer in the area receives notice, they are able to move forward and protest this matter. That has already been upheld, but that's exactly what TAG wants us to read the statute, read the first sentence, and then stop. Again, I'm going to come back to the same line from the case where statutory words are known by the company they keep. Courts must also construe these words in the context in which they appear in a statute and in light of the statute's general purpose. That's the Court of Appeals in Tennessee walking through how a statute is actually to be read. As we mentioned previously, the legislature used the term relevant market area, but opted not to use it later on in the same section whenever discussing dealers in the area. They could have used relevant market area or dealers in the relevant market area, but they didn't. And that's what we're trying to state today, that you can't just look at part of the one particular part of the subsection and stop reading. In the Hyundai Motor America case, the exact same facts are before us here today. That was the Grayson and Twin City case. This was the ALJ properly ruled that whether the dealers were within a relevant market area is a question of fact that should be left up to the commission. That's exactly opposite of what the administrative law judge did in this case. They took that right away from the commission and determined that the relevant market area is what was stated in these zip codes that were submitted to Higginbotham shortly or around the time that the franchise agreement was entered. As the three-part test signals, the commission is not simply to ensure that a new dealer is going into an open point, if you will, an area that's not a relevant market area, but they also have to weigh the consequences as well for the consumers, for the public as a whole. The commission has the power to protect not only these dealers and the competition in the area, but also the consumers in the area as well. Keep in mind that these dealers are the commercial van franchise. They're not selling a whole lot of vehicles. They're not handling a whole lot of transactions, but we are the sole dealer in Shelby County that's been able to sell this one particular product, and this new dealer has just been appointed just 5 miles down the road from Higginbotham's location in Collierville. The second reason I believe that the commission needs to be able to hear all the facts is because notice was never received. The same legislature that gave the commission the authority and the power to hear these types of proceedings also laid out the process in which a manufacturer is to provide notice to the commission and to the dealers in the area. Neither of those were done. The manufacturer circumvented the statute and tried to go all the way around that statute to make sure that what they were doing was not brought before you here today, and that's what they've been trying to do this entire time, is to keep it out from the public's eye in a final hearing. Third, I would point to the administrative law judge's initial order that we are reviewing here today. We believe that the ALJ abused his discretion when taking away a question of fact from the Motor Vehicle Commission. Now, us lawyers use the word abuse the discretion, which is kind of a technical term, and it sounds very serious, but really what we're saying is that he went above and beyond what he was able to do when deciding a procedural question. He looked at this and said it was a procedural question, but it's actually a substantive question that the Court of Appeals has already stated in the Hyundai Motor America case, and I'm going to quote this case. Hyundai's motion itself as a motion to dismiss is a procedural matter. The substance of the motion, the determination of the relevant market area, is substantive inasmuch as it involves the interpretation of TCA section 5517.114C20 and its application to the existing franchise agreements. This is a determination vested by the statute in the commission. The administrative judge properly ruled that the resolution of the motion required a factual determination was to be resolved by the commission, and the motion accordingly was denied. That was in the Hyundai Motor America case, which is exact opposite of what the administrative law judge did in this case. That's a Tennessee Court of Appeals case. But this question of fact is significantly bigger than simply admitting Higginbotham's area from 2014 is the same as it is today. The actions of the parties, particularly Mercedes-Benz in concert with Higginbotham, performing or putting on advertising events, marketing events, and telling them, including executives from Mercedes-Benz, that they are the sole dealer in all of Shelby County, and then all of a sudden coming in and trying to open another dealership right in our backyard. Finally, you need to consider the precedent that we're going to set moving forward if TAG's motion is able to be upheld in this case. You could allow a manufacturer to manipulate whether or not you ever get a chance to hear a case between an existing dealer and an ad point. You may be able to remove the manufacturer's right or requirement of notice of the commission and the dealers itself. Ruling in TAG and Mercedes-Benz favor would also move against the interests of the courts, the Tennessee Court of Appeals, the Capital Chevrolet case, again, the Hyundai Motor America case, where they've already stated that this is a question of fact for the commission to answer at a final hearing. The Capital Chevrolet case that allowed 6 dealers to protest the establishment of one new ad point. The Jim's motorcycle case that the court again says that once a protest is filed, it's up to the commission to set the relevant market area of the existing dealers. And then we also have more recently a Wilson County Motors case here where Carl Black was unable to open a dealership in Mount Juliet after removing that from Wilson County's relevant market area. Again, that wasn't in the new point was not in the current relevant market area of Wilson County, but the the commission still held that they had a right to protest, and they were able to keep that dealership out of there. So for these reasons, we would ask that the commission vote in favor to permit this case to move forward, for us to conduct discovery throughout the next couple months and figure out exactly what the relevant market area is for Higginbotham, and also how to determine how well the market is being serviced by Higginbotham as we speak. Upon hearing all the facts of the case, the commission will be in a better position with all those facts to determine whether a new dealership is warranted. Again, at that point, we can have a final determination as to whether it's warranted or not at this time on a very strict, narrow interpretation. Higginbotham is simply requesting that the continue to uphold the well-settled law that affected dealers in the area have a right to protest whenever they've invested so much time and money and resources into a metro market such as Memphis for a dealership of a commercial van franchise as we have here today. Higginbotham therefore would ask that the commission hear all the facts and evidence before dismissing this case on a very narrow interpretation of the statute, and allow the parties to move forward to determine the relevant market area, how well they're servicing that market, and the propriety interests Higginbotham has in that market. Thank you.
Thank you, Mr. Mason. Mr. Hutton?
Commissioners, in this case, it was admitted before the administrative law judge that when Higginbotham was assigned their franchise, that they were assigned a territory, a relevant market area, by Mercedes, and that relevant market area did not and never has included the zip code where TAG is proposed to go as a dealer. So there are two questions really before the court today. The first is whether or not the statute we're talking about, TCA 5517-114C20, is violated when a manufacturer intends to start a new point, a new dealership, in an area that is admittedly outside of the relevant market area that was assigned by that dealership, by that manufacturer, to a protesting dealer. And the second issue is whether or not summary judgment is an appropriate vehicle to resolve those issues. So to kind of provide context, I think that the facts are important. TAG has been selling Freightliner Sprinter vans in Memphis since 2007. Now, the Sprinter van is made by Daimler, and it's marketed both as a Freightliner product and as a Mercedes product. It's the same van. They just put a different logo on the grill and on the back. So from 2007 to 2014, the only dealer in Memphis, in 38118 in the Memphis zip code, selling the Sprinter vans was TAG. In 2014, Mercedes of Collierville, not the Mercedes, there's a Mercedes dealership in Memphis that's near TAG, but we're not talking about that. We're not talking about Mercedes of Memphis. Mercedes of Collierville was granted a commercial dealership agreement to allow them to sell the Mercedes Sprinter commercial products, and they were given a territory. And they've admitted this blow, and the territory was given in a January 21st, 2014 letter by zip codes. And the zip codes are basically the area outside of Memphis. They're located in Collierville, but they're mainly zip codes in Arkansas, down in Mississippi, in Tennessee. None of the zip codes are the zip codes where TAG is located. So what ended up happening then from 2014 till 2000 to present, there were two dealerships selling Sprinter vans. Freightliner decided that they were, in 2020, that they were going to stop selling the Sprinter vans through their Freightliner franchises. And so what they did is they came to TAG and they proposed to start discussions to making TAG a Mercedes dealer so they could continue with their business that they've been doing since 2007, selling commercial Sprinter vans and parts. And then this protest ensued. Now, if we look at the language of the statute that we're talking about, and I think that that's important because the statute says that basically it violates the law. The commission may deny a license to a distributor who granted a competitive franchise in the relevant market area previously granted to another motor vehicle dealer. Relevant market area as used in this subdivision means that area described or defined in the existing franchise or dealership. Now, it's interesting. The statute doesn't say anytime somebody wants to add a new point, you have to go to the motion. What it talks about is it violates the law if a manufacturer wants to put a new point in the relevant market area that was previously granted to somebody else. So that granting language is talking about not something that the commission has decided, but something that's decided as a matter of contract between the manufacturer and the dealership. And it goes on to say relevant market area as used in this subsection means the area described and defined in the franchise agreement. Now, that's not the end of the story, because there could be an instance where a manufacturer wants to place a new point in a territory previously granted that may still be permissible if the commission determines that it's adequate and appropriate under all the facts. So basically, what this statute does, it doesn't say, and it's not written by the legislature to say any time a manufacturer wants to add a new point, that basically the commission has to decide whether it's appropriate. No, what it says is it's a violation of the statute if a manufacturer wants to put a new point in an area previously granted to another dealer. So let's think about now what my colleague with Higginbotham is proposing is that really any time there is to be a new point, that basically that person would have a right in Tennessee to come before the commission. So let's think about a hypothetical. Let's say you had a new manufacturer that was making new electric vehicles, and he went to a proposed dealer in Nashville and said, I'm going to give you a dealership to sell these new electronic vehicles. Now, I'm planning to go through the entire state, but right now, your territory is Davidson County. That's the territory that you're bargaining for. And then let's suppose a year or two later, that same manufacturer wanted to add a point in Knoxville. Well, could that dealer protest and say, well, the last 2 years, I've been selling kind of cars everywhere? No, because they bargained. They bargained for a particular territory. The territory that they bargained for was Davidson County. So they shouldn't be able to complain because that same manufacturer then adds a new point that's in Knoxville. Well, that's the way the statute reads. The statute talks in terms of, is a manufacturer putting a new point in a territory previously granted to someone else? Well, when we were on summary judgment, what's very critical here, there's a proceeding where basically what the law does, it says if the critical facts are not in dispute, then a judge can rule as a matter of dispute. Like the Honda case, for example, where there wasn't a territory assigned in that particular case. So there was no clearly defined territory. But that's not what we have here. In the proceedings below, before Judge Bagley, Higginbotham admitted and conceded that there was a territory that was assigned in 2014 when they got their franchise by Mercedes to Higginbotham. It was assigned by zip codes, and the zip codes never included the zip codes in Memphis where the tag dealership is proposed. So the question then becomes, if that is true, and they've admitted that, if they've admitted that fact, then can this statute be violated? And what we argued is that it cannot. If it's clear that the manufacturer gave a territory, and it's clear that that territory is not the territory where the protesting dealer is, then the statute has not been violated. There's nothing for the commission to do, and so therefore, as a matter of law, it was appropriate to grant what we call summary judgment. Now, is summary judgment appropriate? Summary judgment is an appropriate vehicle in administrative cases. There are two cases from the Tennessee courts, the Schofner case and the Yoakley case, that say it is clear that a judge can decide something on summary judgment. And actually, that's to make y'all's work easier. It doesn't deprive the commission of jurisdiction, as we see in this particular case, because if a summary judgment is granted by an administrative law judge where they've said, we look at these facts, the main facts, the material facts are not in dispute, I'm going to rule as a matter of law. The aggrieved party can either appeal to the full commission, as what happened here, or the commission has the authority on its own right to review that decision of the administrative law judge. What it does is it's a vehicle that courts, civil courts use all the time to keep courts and commissions like yourself from logging through and trudging through long days of hearings when really it's not needed because there's no fact for you all to decide. And so we would submit that the administrative law judge was correct when he said once they admitted that Mercedes assigned a territory by zip codes from 2014 to present, and that territory has never included the area where TAG is the proposed dealership with TAG is located, that basically that's the end of the story. Because the statute does not say anytime there's a new point to be made, the commission should have a hearing. No, it says it violates the statute if a manufacturer puts grants a franchise in an area, in a relevant market area previously granted to someone else. Now, there is a provide and there's language afterwards about a notice and having a hearing. That only comes into play if a manufacturer, it's either unclear or if the manufacturer wants to put a new point in the territory previously granted, but the territory can support it. So, there was some mention of the Hyundai case. I know it's difficult when talking about these cases, and I'll just briefly address that. The Hyundai case is really not on point. The Hyundai case was a case where there was a motion to dismiss filed by Hyundai that was denied by the administrative law judge, and then the Hyundai tried to circumvent the commission and go to Chancery Court and seek basically what we call an interlocutory appeal, circumventing the commission. The holding in Hyundai is simply that the Administrative Procedures Act does not contemplate an interlocutory appeal of a denial of a motion to dismiss by an administrative law judge. But ultimately, Hyundai doesn't have anything to do with this case because this is a summary judgment case, and we have two cases from the courts on summary judgment that say summary judgment is an appropriate vehicle. It doesn't mean you don't have authority. It just simply means if the facts are so one-sided, once they admitted below that Mercedes gave them a territory and the territory was by zip code and did not include the zip code where TAG is located, that basically the statute cannot be violated. So my colleague wants to interpret Hyundai again to say that always there should be a hearing. That always, if anyone wants to protest, there should be a hearing. The problem is that's not what the statute says. And as my colleague said, we're limited to the words of a statute. Commissions, just like courts, they have to follow the text of a constitution or the text of a statute. What does the statute say? If the legislature would have wanted to write it to where any time there was a concern about a new point being placed, they would have written the statute that way. They didn't do that. So we would submit that Judge Bagley correctly ruled that summary judgment is proper. The case law, the Schofner case and Yoakley say it's clear that they can do it. It doesn't deprive you of jurisdiction, as we are here. They appealed to you. You all are able to review to see if you agree with that judge's determination. And we think that the law, it doesn't make sense. Higginbotham got the territory they bargained for. When they got the Collierville dealership, when they got their territory with a list of by zip code of their relevant market area, which has been conceded, that's what they bargained for. That's what they got. They can't complain now that Mercedes wants to put another point in an area that never has been part of their bargain for territory. So with that, I would entertain any questions that any of the commissioners may have.
I actually would like to hold questions until all the arguments made so that the commissioners can hear all of the argument because they may have different questions afterwards.
I'm sorry, I thought that was part of my time.
No, it's not part of your time.
Oh, okay. I would just ask this commission again to think about the meaning of the statute that we're talking about and look at the words very carefully, because the statute specifically says that the commission may deny a license to a distributor who grants a competitive franchise in the relevant market area previously granted to another motor vehicle dealer. Relevant market area, as used in subsection C20, means the area described or defined in the then existing franchise dealership of any dealer or dealers. American Honda case actually said that it's contemplated by this statute that manufacturers will assign a market area to a dealer. Why would that matter under the view that my colleague is proposing to you all? Why would it matter? It matters. The way the statute's written contemplates that, hey, there will be an agreement between the manufacturer and the dealer. If that's there, if it's a specific relevant market area which they've conceded, and if the new point is outside of that, the statute cannot be violated. Thank you.
Thank you, Mr. Hutton. And Mr. Ferguson, do you want to argue on behalf of the respondent?
Thank you, Your Honor. I don't want to mess up Mr. Hutton's motion because that's his motion that was granted. So I will be brief. Do not interpret that as we think the judge got it wrong, because we don't. We think the judge got it right, but it's his motion. But I want to address a couple of things. First, and I don't want to make this civil procedure 101. Those of you who've been to law school don't want to relive that, and those of you who've never been to law school don't want to live that. But I want to point out some things because we have been asked to comment on the Hyundai case, and I'd like to do that. Hyundai filed a motion to dismiss saying you don't have jurisdiction to hear the protest. Okay? So everything counsel talked about earlier when he talked about the manufacturers don't want you to have power. They don't want you to have authority. Maybe that's what Hyundai was doing because they said you don't have jurisdiction. Mr. Hutton's motion doesn't say you don't have jurisdiction. So don't hear him saying you don't have jurisdiction. That's not what he has said. In fact, he said you do have jurisdiction. You do have jurisdiction. So all this argument you heard about the big bad manufacturers, it's not really relevant, okay? I've been doing this for about 33 years. I know I look younger than that, but it's a common theme. But let's turn the lights on. Let's pull it back. Let's talk about what this is about. Hyundai filed a motion to dismiss, and it was denied. Hyundai said, we don't like that. We're going up on an interlocutory appeal. I got to tell you, before I went to law school, I had no idea what that was, okay? What does an interlocutory appeal mean? Let's say we're down there trying a case. I make an objection. The judge goes overruled, and I go, oh, I want an interlocutory appeal. I'm going right up to the Chancery Court and get that decided. It is outside the norm that a party can make an interlocutory appeal. In other words, while the case below is still going, it's not final. You have to show exceptional circumstances to get an interlocutory appeal. And the appellate court said, Hyundai, you don't have those. Those exceptional circumstances do not exist. Guess what, Hyundai? We don't have jurisdiction to hear your appeal. We can't hear it. So that's what the Hyundai case was about, was is there this right under those circumstances for a party to file an interlocutory appeal? And the appellate court said, no, Hyundai, you haven't met the requirements for that. Now, does that mean that Hyundai's wrong? No, it's just different than this case. But one thing that the appellate court said in the Hyundai case that I do want to draw your attention to, even though it's in dicta. What is dicta, right? Dicta means the court kept talking about things that weren't essential or necessary to its finding. The holding in the Hyundai case is we don't have jurisdiction. They could have stopped right there. Anything they say in dicta is not technically binding because it's not outcome determinative of the case. All right? But one thing that they did talk about, among other things, is they said, thus, under the plain language of the statute, it is the Commission's duty to make a determination of the relevant market area, in quotes, relevant market area, defined as, quote, that area as described or defined in the then existing franchise or dealership of any dealer or dealers. Okay? You've already heard that language before. Well, think about it. Why are we here today? Mr. Hutton filed a motion for summary judgment, which is what? It's a trial. It's a hearing. And his motion for summary judgment is very, very narrow. He said, intervener, Tag Truck Enterprises, moves for summary judgment to dismiss this contested case as a matter of law prior to hearing. The protest filed by Higginbotham, I'm going to shorten names, Collierville dealer, fails as a matter of law since there is no genuine issue of material fact that Tag's location is not within Collierville's relevant market area. That's it. Now, he submitted proof to support that. But what he was doing is this. He's saying that to prevail in their case, they have to show you certain facts. And guess what? There's one material fact they cannot get around. And if they can't prove that fact, the case is over. That's what summary judgment is. You sue me for negligence. There's a lot of elements to the cause of action of negligence. But if you can't establish one of them, the judge can grant summary judgment. If somebody had come in and filed a protest before this commission and said, I want to protest the ad point of a Chevrolet ad point, okay? Could they get a summary judgment? We don't know, right? We don't know the facts, right? What if they're not a dealer? Well, sure, they'd get summary judgment. Why? Because they can't prove they're a dealer. So they lack standing. Here, to get standing, the court is saying they have to fit the relevant market area. So when they say we want a hearing, they had their hearing. It was the motion for summary judgment. Everybody knows you've got to get your evidence in on the issues to contradict what the other side is saying is undisputed. They didn't dispute it. In fact, in so many words, they admitted it. At one point in their filings, they said the zip code identified on Exhibit A are the assigned relevant market area for Higginbotham. Let me read that again. The zip code identified on Exhibit A are the assigned relevant market area for Higginbotham. They've admitted what the relevant market area is. Now, they go on to say what you heard counsel say very eloquently, which is, but what they're trying to do is take the statute, take the words of the statute and say, let's read this real liberally. Let's be liberals about this, and let's throw the words out the window. And what they really meant was this. So we should have standing. We should be able to bring more litigation. They want to expand it beyond the words. And if you don't think those words that the legislature put in there meant something, ask yourself, how does this statute read with those words in there? If you imply their interpretation, then you're going, why did the legislature put this language in here about what the relevant market area is as defined in your franchise if it doesn't mean anything? In their world, it's meaningless. It does not mean anything. We are literally going to ignore the statutes, apply a liberal reading of it, and come up with everybody has standing? I don't think the state of Tennessee intended that. I don't think the legislators intended that. I don't think the dealers who supported this original statute intended to give somebody the right to protest something beyond what's stated in the statute. I think the people who put this together knew what they were doing, and I think the words say what they mean. I really do. I think that's there. So that's procedural 101. You probably won't pass the bar exam with that, but that's kind of what's going on here. This is a different animal than Hyundai. You were told earlier by Your Honor about motions for summary judgment, genuine issue of material fact. There is no genuine issue of a material fact. The material fact being this area has never been assigned to them. Council said you won't see the dealer agreements in the record. It's true. It's true. It's not in the record. What's in the record is an affidavit that says here are the areas that were assigned, and also an update that was sent out in 2017. Both times the area in question was not in the dealer's contract, okay? The zip code where tag is going to be. And in fact, when the update was given, it was given to both section Roman numeral 2E of the Mercedes-Benz Passenger Car and Light Truck Agreement, and also pursuant to Article 4 of the Commercial Vehicle Dealer Agreement, the agreement that we're about today, commercial. In the 2014 letter that went out, basically said if you want to see your area, go to Netstar or whatever the online deal and look under dealer agreements. That's where you can see your area. So this has always been a part of the dealer agreement as it has been written, and that was not in dispute. In fact, they admitted this is the correct area for what we were assigned under the contract. So that's all I really have. I don't want to take up a bunch of your time. I appreciate your time, and if there are any questions, I'll get them at the appropriate time. Thank you, Your Honor. Thank you, Commission members.
Thank you. And does petitioner wish to make a rebuttal? You have 10 minutes if you do. Okay.
There's a lot of talk about what was admitted in our pleadings, and there was also talk about this affidavit. As I mentioned previously, there was never any relevant market area in our franchise agreement. The declaration or the affidavit that was submitted was from January 21st, 2014, a letter identifying Higginbotham's, quote, area of influence, AOI. Those are the zip codes that they're referring to. Those are the zip codes that they're stating that we admitted was our relevant market area. Never was identified as the relevant market area, but AOI, area of influence. Then in 2017, when that area of influence was amended, it says this letter is revising the area of influence and the primary market area. That was the first time we've ever seen primary market area. The only time that Mercedes-Benz or TAG has submitted evidence showing or identifying the phrase primary market area. It's always been area of influence. And so Mercedes and TAG today are stating that area of influence and primary market area is one and the same, and they're both the same as relevant market area as under the statute. Even though in the 2017 letter it goes on to state identifying the AOI and defining the AOI as also defining in a separate sentence defining the PMA or the primary market area. So the idea that there was no material dispute is incorrect as to a material fact of the case. When they were submitting zip codes for an AOI, they were submitting zip codes for a PMA, but they were never submitting zip codes for a relevant market area. Also, we have yet to see any relevant market area for the TAG dealership. Because this is so early on, this is under summary judgment standards, we did not have an opportunity to go through discovery. So we don't even know what their relevant market area is and how that may overlap with ours. Not permitting this to move forward today, we will never know what their relevant market area is and how that works with us. If the defendants or the Mercedes and TAG is correct today in their argument, then we have no such Wilson County Motors case that we had here, because that wasn't within the relevant market area. We have no Jim's motorcycle case because that protesting dealer wasn't within the relevant market area. And we also don't have the Grayson Hyundai case from 2016 because that proposed location wasn't within the relevant market area. Just because there's a new point assigned, they're stating that it's always going to be outside the relevant market area, or at least in this instance, it's outside of the, quote, relevant market area. In summary, I would just ask that we have an opportunity to receive all the facts, present all the facts to the commission, and determine what our relevant market area is at a final hearing, and not assume that the area of influence or the primary, what's the other one? Primary market area is the relevant market area that we were to be received in 2014, and that relevant market area as of today. Thank you.
Mr. Mason, just stay up there if you would, please. Now, the procedure we will follow now is I will allow commission members to ask as many questions as you want. We can go back and forth between the sides, the different parties, if you wish. We'll start with the petitioner since they just finished, and then any questions for the intervener, and then any questions for the respondent. If you then have follow-up questions for other parties, that's fine. I'm going to let you answer all questions that you want to, or ask all questions that you want to. And then I will give you some brief instructions as to the law you must follow before your deliberations, and then I'll turn it over to the chair. So questions are now available for Mr. Mason.
Commissioner Norton. Mr. Mason, you mentioned that Mercedes-Benz Collierville or Higginbotham entered into marketing with Mercedes-Benz to market van sales. Is there anything in writing to that effect as far as the collaboration between Mercedes-Benz and Higginbotham to that effect?
Not that's been submitted to the record, and we haven't had an opportunity to review all of the records to determine if there was anything.
All right, any other questions for the petitioner at this time? All right, and are there questions for the intervener? We'll call Mr. Hutton up. Or it was intervener's motion that was. Questions for today? Well, before we ask Mr. Ferguson to get on his feet, are there any questions for the respondent? All right, I see none for the record. Well, then we can move on to my final charge for you. Go right. Yes, fine. Go right ahead.
I think in the hypothetical situation of, we heard about the Nashville and the Knoxville dealerships, we heard about the electric dealers, and all of those hypotheticals, I would point back to the Court of Appeals where it did say that we would have a right to protest if we receive notice and are considered I would think that whenever the protest is filed, the commission hears all of the facts and then has an opportunity to determine whether they actually are within the relevant market area. But once they receive that notice, then they would have an opportunity to protest that. If the notice was received, yes.
Commissioner Jackson.
On your microphone, please.
Okay. I'm not close enough. Thank you, Judge. In reference to the 3811 zip code area that we're speaking of, has Higginbotham sold cars in that zip code in the past? Do you have any information?
Have they sold Mercedes-Benz vehicles in the past? I don't have that information off the top of my head. I do know that the amount of vehicles that are moved out of this dealership are very small, but I don't want to put on the record that we have sold or that we have serviced vehicles from that market, so I don't know that.
Any other questions from the commission for any of the parties?
Commissioner Norton, I have a question for Mr. Hutton, please. Mr. Hutton, I'm the sole independent on the commission, so I'll have to catch up a little bit here. But you mentioned the relationship between Daimler and Mercedes, and I'm trying to understand that. You said they're just a different tag or brand, correct? Can you explain that to me a little further?
Daimler, the Tag sells the Sprinter van. Think of a FedEx van. That's a Sprinter van. You know, the FedEx trucks that are going around. So the Sprinter van is made by Daimler, which is a big corporation, but they market it under two different lines. They marketed it as a Freightliner, and then they marketed it as a Mercedes. And they had Freightliner dealers selling the Sprinter vans that they'd put a Freightliner decal on, and then they had Mercedes Sprinter vans that they'd stick their Mercedes decal on. So we Tag started selling, we're the only ones selling the Sprinter vans in Memphis starting in 2007, and the parts, had a lot of part sales until 2014. And in 2014, the Sprinter van, that's when Mercedes of Collierville got its territory and was sent a letter with the signed territory. And then we both sold till 2020 when we got a notice that that Freightliner was ceasing. They were ceasing to sell the Sprinter products through the Freightliner. They were only going to sell them through the Mercedes going forward, which obviously would be devastating for our dealership if we didn't. That's when they were proposed.
So the parts interchange.
Oh, they're the same part. Literally, they come to us in a Mercedes box. The only difference in the car is the logo. Excuse me, it's not a car. It's the truck. Literally, it's the same. It's just marketing.
See, I understand now. I didn't before. So it's kind of like Honda and Acura, Toyota, Lexus. They're similar relationships. Okay. I was just trying to understand. I didn't understand the
No, that's sort of that was to give the commissioners the background of, to why we're here, because Freightliner contacted us and said we're not going to let you sell Freightliners anymore, and we sell over $40 million of parts a year. I mean, it's a huge. We've invested a tremendous amount of money, you know, selling these Freightliners.
I understand now. Thank you.
Currently, the Freightliner dealership and the Mercedes store, how close are they now before they discontinue the product?
How close? Well, like location-wise?
Location-wise, yeah.
Okay. The Tag is in Memphis, the 38118 zip code of Memphis. I don't know how familiar, Commissioner, you are with Memphis. That's kind of in the old Mall of Memphis area, sort of American Way. It's kind of in the center of the city near I-240.
Miles. I mean, how close?
You know, I don't know. The Collierville is a town. It's probably at least 5 miles away. I don't know, Commissioner. I don't know. It's not in Memphis. It's in Collierville, which is a separate municipality in Shelby County. And the letter, which I believe is of Carolyn Deschamps, shows the territories, none of which are the Memphis zip codes.
But the Freightliner brand, Mercedes never thought about. You're no longer going to sell Freightliner. Therefore, why wouldn't you? Any thought putting in Mercedes in that location instead of Freightliner?
I'm sorry, Commissioner. I didn't.
Okay, so they're discontinuing Freightliner.
Yes.
Was there any discussion on, okay, we're not going to sell Freightliners at this location, we're now going to sell Mercedes?
Well, what happened is when they ceased selling Freightliner, they began discussion with my client Tag about making them a Mercedes commercial dealer, because the Mercedes dealer in Memphis didn't want to be a commercial dealer. So there's a Mercedes dealer in Memphis that sells, you know, the top end Mercedes, but it doesn't have the commercial point. So they're not objecting. They don't care, you know. So they came to us to start discussions about making Tag a commercial Mercedes dealer so it could continue with the sales it's been doing since 2007. Okay.
Any further questions from commission members for any of the parties?
I have a question for counsel for the Mercedes group. Do you know off the top of your head, are there a lot of instances where this commercial designation is going to non-Mercedes franchises, such as a Freightliner store or a, you know, some is that a common thing with Mercedes where they do hand out the commercial franchise to a non-Mercedes dealership?
It's not in the record, so I don't know whether I can answer.
Okay, yeah, you may not know.
I don't mind answering the question.
I think it is outside the record, as it was stated. The affidavits that I'm going to talk about in a minute are the only facts in the record, and you all have those available to you to review. And if you want to review anything during your deliberations, you should. Any other questions?
I'd be glad to answer, but it sounds like I shouldn't, but
No, it's beyond the scope of the record. Okay, no further questions. Then I'll give you the charge and turn it over for deliberation. Commission members, you exclusively have the authority to make findings of fact in this case. You are also the exclusive judges of the law, specifically your statutes and regulations and their application to this case. No one else can participate in your deliberations. When the language of a statute or rule is plain, then you must follow the plain meaning of the language. However, if the language is ambiguous, you may give your interpretation of that language so as to explain the conclusion that you reached. The primary statute at issue here has been referred to several times as Tennessee Code Annotated Section 55-17-114C20, to which the attorneys referred, and in a minute I will give you some more directions about statutory interpretation. As sole and exclusive finders of the facts in this matter, you must conduct open deliberations, make findings of fact, and reach conclusions of law. You must make findings of fact based solely upon the evidence already contained in the record. No additional evidence is to be received or considered by the Commission. The evidence consists of the affidavit of Gary Dodson and the declaration of Carolyn Duchesne, with exhibits which were submitted by the intervener in support of the motion for summary judgment. The declaration of Trudy Higginbotham Moody was submitted by the petitioner Higginbotham in opposition to the motion. In making your decision, you must consider the evidence in light of your own reason, training, experience, and common sense. You should not base your findings on speculation, surmise, or conjecture. Documents filed by the attorneys and already transmitted to you, such as their briefs, the motion, and other pleadings, are not evidence. But you may use those documents as guides to assist you in making your findings, but only if they accurately reflect your own independent understanding of the evidence and your own conclusions. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, then you should disregard them. In making your determination, it will be necessary for you to interpret the statute we've talked about. When the language of the statute or rule is plain, then you must follow that language. However, if the language is ambiguous, then you may give your interpretation of that language so as to explain the conclusion that you reach. Words of a statute must be given their natural and ordinary meaning without any forced or subtle construction to limit or extend their importance. The meaning of a statute must be determined not from special words in a single sentence or section, but in the context in which they appear and in light of the statute's general purpose. A statute should be construed as a whole, and it should be assumed that the legislature used each word purposefully and that those words convey some intent and have a meaning and a purpose. The Administrative Procedures Act specifically requires the Commission's order to have 4 parts: findings of fact, conclusions of law, and the policy reasons for your decision. The policy reason is required in your order by the law. The Commission's policy reason for the action states why your decision in this situation is appropriate, and perhaps the Commission attorney would propose a policy statement for your consideration, or perhaps you have one on hand that you've used in the past. Motions to adopt findings of fact, make conclusions of law, the ultimate disposition of the case, and to adopt the policy reason for the Commissioner's actions must be carried by a simple majority vote of the members. Your findings of fact and conclusions of law will become your final order pursuant to the Act. Please be as concise and specific in your findings and conclusions so that they may easily be incorporated in the order by counsel. And if the commissioner is unable in this situation to make a determination whether there are disputed facts, then you must reject the initial order and set it for hearing. As I said before, you may accept the initial order in its entirety, and then you would just change the title to findings or final order. You may reject the initial order and draft your own order with the 4 sections, and that would be your final order. Or you may modify the initial order and accept the order, but perhaps for a different reason, or find different facts, or delete certain facts. If you accept the initial order in its entirety, then you agree with Judge Begley that summary judgment was appropriate and the case will be dismissed without further proceedings and without hearing. If you reject the initial order, then you are denying the motion for summary judgment and it will be reset for a hearing or a trial before you with witnesses and such. And then if you modify the initial order but accept the ultimate decision of Judge Begley in his initial order, then you are accepting his decision to dismiss the case. And if any members have any questions for me, interpretation of the law or procedure, I'm happy to answer those at any time or point during your deliberation. But if not, then I'm going to turn it over to Chair Roberts. And if the commission members find during their deliberations that you want to ask additional questions of council, that can be done by a vote and a simple majority.
Any comments or motions at this time?
Chairman Roberts, I have one point of clarification. Although I know it was provided to us before the hearing today, I'm not finding the declarations in the documents on the iPad. If someone could direct me to them, if I'm not seeing them in the right location.
I
think they were attached to one of
the affidavits for the intervener were attached to the motion. There's a motion, and then there's a FedEx photo of a delivery envelope, and then there's the memorandum of law, and then there's 2 affidavits or declarations attached there, and the declaration for the petitioner was a separate filing.
Staff point them to
and
documents that are in.
Yeah, we need to get these documents to them if they weren't transmitted.
They were transmitted to us beforehand. I remember reviewing the
I'm not
declarations.
sure that separate declaration was, now that you mention that. I didn't transmit them.
I know I've seen the declarations, but I'm not seeing them. I think they were, when transmitted to us, were exhibits attached to the petition and then in the response, and I'm just not seeing them attached in the documents within the iPad.
I'm pulling them up in the file on my computer, so.
Meantime, we can continue on.
Like I said, any comments, or if anybody has a motion at this time, just speak up.
Commissioner Jackson.
Yes.
Chairman, in order to, I guess our first procedure is a finding of the facts. I don't have the contract that Higginbottom has signed with Mercedes-Benz. In order for me to make any type of ruling, I would have to see that contract that Mercedes-Benz has signed with Higginbottom. And also, I was told that they normally notify any franchise if there's going to be a change. I don't have that information for me to look at. I don't have any information that talks about who has zip code 38111. I don't have any information that I can look at where it. Don't have that information. Don't have any information whereas that 3811 was signed to tag. I don't have that information. I don't have any information whereas Higginbottom has ever sold cars in zip code 38111 or trucks. I don't have that in front of me. The at this point, I don't have anything in writing that I can look at and make a decision as far as whether this case, should we follow the decision of the previous judge, or should we make a decision that we need to have a hearing so we can hear all the facts? That's my concern.
And Commissioner Jackson, that's why I was asking for the declarations, because I believe in looking at the ALJ's decision, he reviewed those declarations, he reviewed those letters, and I'd like to review them as well. But if they are as he's read them, I think we do have all the information that we could make a deliberation and a decision if we see those letters. Because to me, it seems pretty clear that the letter defined the market area. And if the letter defined the market area, the statute would say there's no space for us to be involved because this isn't in that market area. And so, based on my review of everything, I'm inclined to uphold the decision of the ALJ, but I would like to see those attachments again after hearing all the arguments to make sure. I know I reviewed them beforehand, but now having the arguments of counsel.
I'd also like to say something. And please. As a member of this commission, it is my understanding that we have broad authority to resolve disputes between dealers and manufacturers. I do not know how we are expected to do this and to fulfill our role in keeping a level playing field for dealers and the manufacturers without all the facts. We don't have all the facts, and this is something that I'm very uncomfortable with. The law says that, we are to determine whether there is the need for an additional dealer. I want to do the right thing in this case, and I'm assuming that everybody else does make the right decision, and I think we need to hear all the facts and not just dismiss this before there's a hearing. I agree with what Mr. Hutton said. The facts are important, and we have got to hear that. I want to hear more about the primary market area, the area of influence, relevant market area. They've said all these things, but we have no details. We don't know about quite a few things, and it doesn't sound like the attorneys do either because there hasn't been any discovery. And I think it would be premature for us to agree with the judge and without hearing the facts. To me, this is something that needs to be a formal hearing. So you need more discussion?
Well,
I'll make a motion.
Let me just address the documents, if I may, so the record's clear in case there's an appeal. So if you all would look at the motion for summary judgment, which was given to you, it's a pretty long document. I've got 42 pages. It was filed on January 14th, 2022. You go through the motion, which is fairly short. You see a FedEx envelope photo. You go through the memorandum of law, which is after that. There's another FedEx envelope photo, and then there's the affidavit of Gary Dodson, the declaration of Carolyn Duchesne.
We don't have that on our iPad.
You don't have any of that?
We don't have the motion. That's the problem.
I received an email the other day from Commission Counsel with all the attachments that were sent to you, and so I'm not arguing at all with you. I was under the impression.
Let me clarify. We received it. We did receive that email.
Okay.
We don't have access to our email. Right now, we have an iPad that just has
and
the
motion
documents
was
that are
not loaded on the iPad.
Correct.
All of the what do you have on your
Well,
iPad?
we've got the order dismissing we've got the ALJ's order, we've got the petition for appeal, we've got the response to the petition, we've got Higginbotham's further submission, and we've got Tag's reply.
And nothing before the initial order. That's
Correct.
what you need.
We got it before, and
Right,
we all
okay.
reviewed those documents.
But you don't have it now.
I'd like to review it again.
I want
and I don't
all
have
of
it
that
now.
to be available for your review.
That's okay.
Okay. And does that have both the declaration and the affidavit and the exhibits to the Carolyn Duchesne declaration is what you're looking for, I think. It has the two letters. Okay, thank you.
I think while we're waiting for those documents, I think we can continue to deliberate. I mean, to me, it sounds like Commissioner Vaughn is agreeing with petitioner's opinion that regardless of where a dealership is established in the state, a dealership of that automotive company has the right to protest. And I read the statute to be, if there's no dispute about what district you've got responsibility for, you don't have a right to protest. Maybe this is the manufacturing representative speaking to a bunch of dealerships, and so I will very quickly get outvoted. And that's the case. That's the case. But I'm just trying to understand the point of, what are we discussing here, or where's the point of disagreement or disagreement with the language of the statute says.
Commissioner Norton, just like to comment that the legislator drafted the Motor Vehicle Commission to protect the consumers, the dealers, and the manufacturers, and to establish us to be referees to maintain it's fair. Now, I'm an independent, but I did read this statute, 5517.14C20, and it talks about the relevant market area. And then I read down further, and it says the manufacturer shall give written notice to the existing dealers and other dealers in the area. To me, that was a little unclear as far as what that is, and I don't see any zip codes or anything in this statute. All I see is an interpretation of what's fair for everybody concerned. So I'm of the opinion that it needs to be further reviewed just by the mere fact that nothing's clear. We have two pretty good opinions of the statute, and I respect both of them. They were argued very well, but me as an independent dealer, common sense applies. I just don't see that at this point. So.
I agree. I mean, I believe the legislature, as always, could be a little bit clearer with the language and why they added an entire second paragraph after a semicolon after the first sentence, which was pretty clear. So I read area as and relevant market area, although it's defined, and then just talks about what are the language, how it's defined in the relevant market area as used in the subsection means that area as described or defined in the then existing franchise or dealership of any dealer. It doesn't even talk about the dealer agreement. It just talks about if you've described it or defined what the area is, which I'm presuming if I look at the letter again that's attached to the affidavit, that's going to be a description or a definition of the area. And zip codes is pretty dang specific. So I feel like they've described it pretty clearly in that area, in which case they wouldn't be able to grant another franchise in that area. And if they did want to, then they'd have to go through the rest of it. That's how I read it. So I take respondents' argument on that, petitioner's argument on that. But yes, they could have been clearer. If they wanted to put in zip codes, they didn't. But they were simply, as I'm reading it, they're saying if there's a dispute about what the area is, boom, that's the rest of the statute. If there's no dispute about what the area is, that's the first sentence. And I feel zip codes is pretty clear, pretty specific, that there's not a dispute. Would be allowed to put in a new. I don't subscribe to the idea that if the first-in-time dealer in Nashville, I don't think he can protest when they try to put one in Knoxville. If all of his dealer description says, boom, you're the dealer for Nashville, shouldn't matter what they're trying to do in Knoxville.
And then that was, that the discussion with that one sounded like it was more about, kind of a what if it was electric, the EVs and all of that type situation, and he was the only one. And I get that part, but the other thing that I want the commission to also keep thinking about is, this is a big deal to the dealers involved. This is a big deal to the manufacturer. We're here to make sure it is fair for everybody, and it doesn't need to be one-sided. It's not just, hey, the big bad manufacturer. I don't feel that way at all. It needs to be the right call for the citizens of the state of Tennessee and for that dealer and manufacturer to level the playing field so that they can all say, here's why we think this is the right call. And I think we need to give them the opportunity to do that.
I agree, because you have a manufacturer, you got the dealer.
Yeah.
I mean, is the consumer going to be served well? I mean, I hear it say whoever just draws these lines up, are they available for interpretation? Was that fair? I mean, I get it. If it was so clearly illustrated in an agreement or statute, then why are we here? To determine if it is fair, I guess.
I understand that part.
Yeah. And like I said, I'm an independent, and I've always heard of the big bad manufacturer, but I think there's good people on all sides. I think it's up to us just to get it right for all parties concerned.
I think it's also in the consumer's interest to, have efficient decisions, and based on really is nothing too disputed. Help the consumer to delay a decision months until we to then hear all of the facts. If we don't think we have all the facts to make the decision today, I fully agree with you. But if ultimately we do have all the facts to make the decision today, I think it's better for the consumer to reach a quicker decision than
Commissioner Jackson, I don't have all the facts. I know how to make decisions fair and just when I get all the facts. And reading the document, the judge had indicated to that certain portion of this document we don't need to use as making a decision. I want to make a decision based on the facts in writing, the contract that Higginbotham has, and the contract that TAG has with Mercedes-Benz. That's what I want to look at. And once I look at that evidence, I'm capable of making a right decision what's fair and just. I can't do that today without seeing what I feel that I got to have in order to make a decision on this commission. We've always, I was involved in the case that they quoted, Mount Juliet case. And when they brought that case before us, it was about a day and a half of hearing. And it was all about relevant, who's supposed to sell here. And in this case, the evidence showed that the gentleman that had that franchise had every right, because the evidence was here for us to see that that area that this case was involved in, he had the right for that case, because he had advertised and did all those things. We heard all of that evidence, and advertisement and how you spend the money in those areas to accomplish those areas played a big role in myself making that decision. It was a new subdivision that they built, and nobody was assigned to the area, but this particular dealership was already advertising it. And I can read between the lines when the big guy want to shake down the little guy. I can read between the lines on that. I'm intelligent enough to understand that once I see the facts and the evidence. And I saw those facts and the evidence in that case, and I know I made a right decision. I know this board made a right decision when we made a decision on that case. And some of you wasn't here. I was here. And this is similar. This is very similar. We had another one where manufacturer come in and just automatically want to give a certain dealership an area. Nobody has been assigned to it. And we settled that case, but we had the evidence in front of us to make that decision. I can't make that decision based on a transcript or based on what they put into this case. I just can't do that. It won't be fair to neither party if we make a decision based on just what we're looking at before. I don't disrespect the judge. I just think that we have a right as a commissioner to look at all the evidence and all the facts. And let me tell you something. Once I look at the evidence and facts, it doesn't matter who I hurt. I can make a decision and I can sleep at night. Yeah.
Our duty.
Commissioner Galvin, I just got one question, and I don't care who answers this, but if a manufacturer sends me a letter saying that they're going to remarket my area or my zone, they usually send me a letter telling me they're going to do that, but they also send me a map, and on that map, it specifies zip codes on that map. My question is, when that letter went out to Mercedes, did they have a map of zip codes, or they just told me it was just going to be in that area?
Do any council have facts as to that? Is that in the record?
I think I can speak for all of us that there was no map included. It was just a list of zip codes attachment to it.
Like any highlighted counties or zips saying you're going to do this. I'm just taking it from my perspective. It seems to me that there'd be some kind of direction showing this, and that's something that we probably need to see, or the manufacturer could have done, or maybe Mercedes got it. I don't know, but to me, there should be some kind of sign on that.
You know, it's not in the record. It was never submitted.
There is a list of zip codes that's attached to a letter that's attached to Ms. Duchesne's affidavit, which is being made. Copies are being made for you now. I think Mr. Hutton actually was on his feet first.
Commissioner Galvin's question, although they provided the zip codes, they didn't provide a map. They didn't assign those zip codes to the map. So unless you have pretty innate ability to know which zip code is where, you're not going to know what that area looks like.
Mr. Ferguson?
Mr. Hutt, when you get this affidavit and you look at the letters, I would ask you to please look at the headings which say state, county / zip code, and then there's the numbers. Zip code designation. Then there's another that's AOI description.
No, keep your voice up, Mr. Ferguson, so the court reporter can hear you.
Sorry.
It's hard to hear over in this corner.
I'm sorry. I apologize. Yeah, when you look at it, there is no map attached, but there are those descriptive items, columns that follow.
Mr. Norton, I have a question for any council on the commission or any dealers. Is it common for a relevant market to change? Does it change, or does it stay the same as it described? Changes. Does it change? I mean, I'm an independent, I don't know, but I'm just curious, does it change?
I was notified in the last 3 months that there are some changes to mine. I have not sat down and dissected what I'm really getting into, but usually not drastic.
Right. Well, same thing for me. Mine is like, I get the map also, and it'll show like this whole area of Memphis, Shelby County. It doesn't carve out like 1 or 2 zip codes. It's a blob.
And typically we have census tracts as well, not just zip codes. It's actually lines drawn, not specific to an exact zip code. They're census tracts. So the map does help. I know we keep bringing up the map, but it does, when you can look at it. And I don't know how many zip codes Collierville has. How many zip codes does Collierville have? Several, I guess. So I don't know.
Why would these change? Would they change for the benefit
Population
of the
changes.
consumer, the consumer service?
Typically,
the consumer, yeah.
if a new business moves in and there are a huge amount of homes built in a certain area, then they'll reassign based on proximity and where do you sell your vehicles, to who sells the most, who picks up that. So
there were big changes. Like in 08, 09, when a lot of dealerships went out of business, you would inherit big swaths of land occasionally. If there was a neighboring dealer that was out of business, your dealership might inherit his area. So that happened a lot too back in 08, 09.
Curiosity, being independent, so if there is population change, and if the administrative judge did file summary judgment or grant a summary judgment on this, I mean, would they have looked at these types of things instead of an order that came in with a bunch of zip codes? Would they have made a determination based on what to do to service the customer on something other than that list that was 2014? Does that make sense?
You would have certainly had someone sit down and go over it with you, for sure,
Okay.
as to why they're doing it and get your feedback.
Yeah.
At least I do. So I'm just speaking because they definitely made the right call. I was not on the commission back with the Mount Juliet deal, but I can tell you, I knew a little bit about it. I wasn't on this board, but they 100% made the right call based on the amount of time that Wilson County Motors had invested in that specific area. And I think if they'd have gone without this board hearing it, I really believe that would have really hurt them.
Well, my concern with that is, did it help the consumers? If that population was dense, I mean, I would argue that that probably needed a point. I don't know. I'm learning this. To me, it's about being fair, and that's all parties. Right. The consumers are not here. You want to line up half the population of Memphis and say, what do you guys want? What are you going to be served? So we have to consider that as well.
But also, it's not just about the zip codes. To me, it is the dealer has the right to come before this commission. That is what we are here to do. We have a duty to hear them out, period.
Commissioner Jackson, also, with the zip code that Mercedes being decided 38111, I would have thought, since you had Higginbotham I don't know where 3811 close to some of those zip codes they're talking about now. To me, it seems as though that Mercedes-Benz by Higginbotham already in that business and doing it, and probably doing it very well. I don't understand, and I don't have nothing that I can look at where the manufacturer decided to offer to tag and create this 381 zip code. I love to know that. Why did you not offer to Higginbotham, but you went and created another zip code and you offered to tag? I'd love to hear that. I don't have that information in front of me. And that had to come from the dealership, the manufacturer.
We can hear you.
You can't hear me?
I can
Can
now.
you hear me? These zip codes have tracks in them, and the tracks can be assigned, I believe, to two separate dealers, depending on the location. Am I right? Okay. So that's something else we've got to keep in mind. Zip code does not tell us the track. The map is what tells us.
Commissioner Evans here. So I want to circle back on the conversation that was had around the maps and what's contained in the maps. So if it appears that having the map provides helpful information as a dealer to kind of knowing, what your lanes are, your silos, your space, about your business, right? So not having a map, does that kind of cloud kind of what you would know about your dealership and kind of where you can and cannot operate?
It'd make it more complicated as a dealer. You'd have to go, hang on, let me look. You're in the right, because it you know how it divides it up to where you've got to really look at it. But at the same time, I wouldn't get too hung up on that part of it, just from that standpoint, in my opinion.
Is less than 2 miles out of my, quote, PMA. So I can't display cars there. I can't have events there. I'm in the zip, but I'm not quite stopped at Bell Road. Had I gone all the way to Interstate 24 in that same zip, then I would be able to. So the map really does matter now. I'm just speaking on Ford Motor Company. Not every manufacturer, some people do strictly look at zip codes, this is it, and then that's it. But in our case, we look at specific, it stops at this bridge, this road, it cuts across, and it picks up. It's really hard to, without the map, it's and Jim knows as well as I do, it's got color and yellow here, red here, and it's very easy to step out, and people will, at least in our world, will tell you, hey, that's my PMA. Even though it's the same zip, you stop at Interstate 24, and now you're on mine. So I can't have a classic car show at the Ford Ice Center because it's not my PMA.
Luxury manufacturers are also a little bit different too, because they'll have, here's your AOR, area of responsibility, then you'll have attached AORs, which is free space, or you're supposed to take care of them, you won't be penalized. But so every manufacturer is different, so we'd have to know a whole lot more about the way Mercedes does theirs, because I don't know that there is a Mercedes dealer at this table. So that's the other thing. I can't tell you what they do. We would have to have them tell us, what do you do? How do you do this? What's the method behind the madness? So,
and I think the further discovery is really ultimately what everyone is wondering. We're hypothetically speaking, but I think ultimately that's all we really want to know is
we need more.
There's further information we just don't have.
So with that being said, any more discussion? Because I would like to make a motion that we allow a formal hearing and we overrule the judge's decision.
Second that. Commissioner Kramer. Second.
Discussion. Would you, Executive Director Lawrence, will you call the roll on this vote?
Sir, the motion is to reject the ruling of the summary judgment dismissal of the administrative law judge and move forward to allow a formal hearing. Commissioner Levy? No. Votes no. Commissioner West?
Yes.
Votes aye. Commissioner Speaker?
Aye.
Votes aye. Commissioner Melton? Votes aye, Commissioner Elam.
Aye.
Votes aye, Commissioner Barker.
Aye.
Votes aye, Commissioner Chairman Roberts.
Aye.
Votes aye, Commissioner Galvin.
Aye.
Votes aye, Commissioner Norton.
Aye.
Votes aye, Commissioner Vaughn.
Aye.
Votes aye, Commissioner Jackson. Votes aye, Commissioner Kramer.
Aye.
Votes aye, and Commissioner Evans.
Aye.
Votes aye. The motion carries, and the commission rejects the ruling of the ALJ and will proceed to allow a formal hearing.
And now, there has to be a final order produced, recording your decision. And I believe it has to not just deal with the motion, but I think there has to be a short section for facts, a short section for conclusions of law, and then your ultimate decision and the policy reason. And because that's what the Administrative Procedures Act states. So, for instance, and I don't want to get involved in any of your deliberations or anything, the findings of facts section could just say you find there are insufficient facts to determine whether there's a dispute of fact in this matter. You can add some facts to that if you want, some other explanation. There has to be some explanation. And then your conclusion of law would be, for instance, that the commission believed that the summary judgment standard was not met in this case. Statement, and your ultimate decision. But Ms. Lawrence,
So we could get help with the wording.
I believe we have a
Staff?
standard purpose statement that we can attach. I remember the last hearing we had one, and so I think for the conclusion of facts, we simply state the commission decided we do not have sufficient facts to make a determination that, taking all facts in favor of the petitioner or in favor of the respondent, that we could not find that the facts were not in dispute. And as a conclusion of law, we could say we did not have sufficient facts, and based on the conclusions of law, the petitioner did not meet the summary judgment standard, which would allow for this matter to be dismissed on summary judgment, and thus a hearing is ordered or required.
I think that's fine. And in these situations, does commission counsel usually draft up that language?
Yeah, I can draft that.
Okay, perfect. And so to give some further instruction on that, if you want to adopt what Commissioner just recited, then you need to take a vote and on that language and state that you accept the facts as recited, the conclusion of law, the purpose statement you're going to get from what's been used before, and then the ultimate conclusion by majority vote, then that would be adopted.
Make a motion that how I just summarized the conclusion of facts and the conclusions of
Yes.
law and our previous policy statement be adopted.
Commissioner West seconds.
Does the court reporter has what you just outlined? Play it back, and then I
find the spot,
suggest
that
that
might
the
take her a
staff.
moment.
They have it.
We're also recording it.
Okay, y'all have it?
All right.
Okay, good.
I'm
So we've
through.
got a first and a second? Yes.
And
okay.
a third.
And a
We're
third.
fine.
I'm not
We're
doing a fancy
covered.
thing. I'm through.
We need further discussion.
If power goes out, we're okay as well.
Executive Director Lawrence, will you call the roll?
Yes, sir. The motion is to adopt the levy language, and the motion was made by Commissioner Levy, seconded by Commissioner West. Commissioner votes aye. Commissioner West
Yes.
votes aye. Commissioner Speaker
Aye.
votes aye. Commissioner Melton votes aye. Commissioner Elam votes aye. Commissioner Barker votes aye. Chairman Roberts
Aye.
votes aye. Commissioner Galvin
Aye.
votes aye. Commissioner Norton
Aye.
votes aye. Commissioner Vaughn
Aye.
votes Commissioner Kramer
Aye.
votes aye, and Commissioner Evans.
Aye.
votes aye. The motion carries. The levy language will be adopted.
All right, and with that, then, the commission members are thanked for carrying out your duties today, and if there's no further questions of me or need for me, then the formal hearing is adjourned, and I turn it back over to the chair for whatever business or adjournment you want to make of your meeting.
Denise, did we have anything left on the agenda from
We
this
have
morning?
concluded our business.
Okay. We
might
just
I
need a
s-
motion to adjourn. Go
Well,
ahead.
might I say one thing, and I need some direction from our legal counsel. I think that I already have set this date, not in anticipation, but considering whichever way the commission voted today. The protest is scheduled for through Friday, December 2nd.
That's correct.
And I will send that out to everyone again. I think I sent you all a tentative schedule of what would happen, but just to remind everyone, and is that, let me look at council, is that? Perfect. That's what I need to know. Forget that. We will cancel that date, and we will consult with council, and we'll come up with another tentative date. We got a little ahead of ourselves, trying to take care of these things in advance. But now,
Okay. We have a motion to adjourn.
So moved.
Okay. Any further discussion? All those in favor say aye.
Aye.
Opposed? Surely not.
Yeah.
Opposed.